Delivery of order, item number 1.
We are issuing notice. You take steps within 7 days. And till the next returnable date, the proceeding of the complaint case number CS 314375/2025 shall be stayed.
Okay. Wait, your lordship. Well, I seek your lordship's leave to mention an item which is in the list at serial number 62 of the supplementary list. You will take net 2. My lord, I want to leave for outside. Get 2, my lord.
You have personal difficulty.
Yes, my lord. Because the
Okay.
matter was disturbed 2-3 times, my lord, and case diary has also come. I have inquired.
62 with item number 43, case diary.
Okay, we'll take it up along with item number 43
My lord.
at 2.
Oblige.
My pleasure, Lordship. Lordship, it's a prayer for listing, my lord. Matter was listed on last Thursday. So while appointing the amicus curiae, CD was also retained, my lord. So it was fixed on the next Thursday, that is yesterday, my lord. But inadvertently, it was reflected as on the next Thursday, there is 11, my lord. So that is my anxiety, my lord. Maybe taken up by Monday, my lord, if possible.
No, it is, date has been fixed on 11.
My lord.
So let it come up on 11.
My lord, I have mentioned it yesterday. I have mentioned it before the coordinate bench, my lord. Mention was allowed, but today the bench is not sitting. That is the problem, my lord. And the registry have given me the objection that since you have not mentioned before the senior bench, so it couldn't be listed.
No, but there is a judicial order of fixing it on
Yes, my
11.
lord, I understand.
It has to be on 11. It has to be on 11.
But
Who passed that order?
my lord, Justice Sanjeev Sharma, my lord.
No,
In the my lord, in the system it's showing as 4-9, but in the order it's reflected as
we
11.
have to go by order sheet.
Definitely, my lord. If possible, my lord, Monday.
No, you have to mention before this said court.
I have mentioned
has-
it yesterday, but today the bench is not sitting. Though my mention
This
was
court
allowed.
cannot change the
My lord,
judicial
my lord.
order.
Much obliged, my lord.
I beg to mention item number 46. City was called for power. City is not there. Like the matter may be fixed another day. 46.
Heard Mr. ABT of Learned Counsel for the item number 46.
City is
Learned
not
Counsel for the petitioner. Also heard Mr. KK Parashar, who prays for some more time for producing the case. Let this matter be listed.
no interim is there. Short break.
Quick date will a quick call. 27.
Oblige.
Please, Lordship, I beg to mention item number 34 and 35, Lordship. There is
Yes.
some difficulty, Lordship. Finally fix it Thursday, Lordship.
You have informed the
Lordship. One time.
Appearing plus.
You have informed both heard Miss N. Kakoti, Learned Counsel for NCB, who prays for adjournment on the ground of personal difficulty. Also heard Miss S. K. Nargis, Learned Counsel for the petitioner, as well as who is,
For other item.
you inform the other counsel also, who does not have any objection. Let this matter be listed when?
Next week, Thursday.
17. 17 of
They're inside the jail for about 5 years.
17. Otherwise, it will not reach if we fix it on other day. Yes.
But I went to item number 57, Lordship. In 57, Lordship, I was supposed to file an additional affidavit, Lordship. My lord, in this case, just now I received the documents from the petitioner, Lord, petitioner friendly. So, my lord, can it be taken up on Wednesday, my lord, with the additional affidavit, my lord?
Heard Mrs. K. Nargis, Learned Counsel for the petitioner, who prays for some more time for filing additional affidavit. Let this matter be listed. 11.
Obliged, Lordship.
Please, your lordship. Lordship, I beg to mention item number 30. Lordship. Case diary was called for
Item number?
30, lordship. 30.
Yes.
Lordship, case diary was called for, perhaps it is not received.
Heard
lordship.
Mr. K. Thakur, learned counsel for the petitioner. Also
Yes, Lord.
heard Mr. K. K. Parashar, who prays for some more time for producing the case there. Prayer is allowed. List this matter on 23rd September.
May I please, your lordship, I beg to mention item number 59, my lord. 59, my lord.
59.
Interim, my lord. Can it be on Monday, my lord? 7th,
Monday it will be difficult. Item number 59.
59, my lord. Case there is there will be interim also, my lord. Can it be on Monday, my lord? kindly?
Why you are praying adjournment?
Fine.
What is the reason for seeking adjournment?
Adjournment, my lord, because we have some difficulties today, my lord.
Heard Mr. D. Bora, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty.
Case there may be
Let-
required.
The case diary is available. Let this matter be listed on 8th.
Obliged, my lord.
8th of September.
Item number 52, hearing matter, lordship. With the consent and other side is present, lordship.
I am for the
Praying for adjournment
petition.
for today, lordship.
What is your prayer?
Prayer is to fix the matter in any other date, lordship, that may be on 19 September. Item number 52, hearing matter.
Heard Miss N. Chaudhary, learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty. Mr. S. N. Krishnatre, learned counsel for the petitioner, does not have any objection. Hence the prayer is allowed. Let the matter be listed on 16th of October.
Lordship, interim order dated 18/8/2025 may be continued in next date of listing. Interim order is there till today, lordship.
The interim order shall continue till next day.
Bless lordship. May I please, lordship, I beg to mention item number 3, lordship. We are filing our affidavit, lordship. Affidavit may be called for, lordship.
Item number 3,
Lordship.
call for the affidavit.
Oh, bless lordship.
May I please, your lordship? My lord, I beg to mention item number 24, my lord, with the consent of other parties. my lord. Lordship, it may come after 2 weeks, my lord.
Heard Mr. What is your name?
JU NM Laskar, my lord.
JUNM Laskar, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. He submits that he has informed the learned counsel for the respondent, who do not have any objection to his prayer for adjournment. Hence, same is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Then the interim order, my lord.
The interim order shall continue the next day.
Obliged.
May I please, your lordship, prayer for listing of anticipatory bail application, though it was fixed on 5th/8, but not listed till date.
11th.
May I please, your lordship, I beg to mention for listing 2 bail application, regular bail application, was filing in 14/8/2025, lordship. Kindly allow for Monday, lordship.
After 14, it has not been listed.
It's listed in
What was the last date of listing?
28, lordship.
What was the order? What was the order on the last date? Leftover. 15th.
Obviously. May I please, your lordship? Lordship, I beg to mention item number 42, lordship. Kindly adjourn for the day, lordship.
Why?
42. Because of some personal difficulty, lordship.
Heard Miss.
N.A. Begum.
Item number?
42.
Heard Miss N.A. Begum, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. Learned additional public prosecutor, however, submits that the case diary is available. Stop. The prayer is allowed. Let this matter be listed on 14th of October.
Inter
The 14th October, no. CD updation is required. Short date, give a short date. 11th, let this matter be listed on 11th of September.
It's interim
The interim order shall continue till next.
of license.
May I place your lordship? As per the instruction of the party, I am paying a listing for withdrawal of BA number 2810 of 2000.
When have you filed? When have you filed the,
On 27/8/2025. Lordship may list on Monday.
Putul? 11th.
Please, your Lordship. Lordship, I beg to mention a bail application for listing, Lordship. Earlier it was listed, but it was not list, Lordship, and I left out, Lordship. Yeah. Scan copy was available, Lordship. So kindly on Monday, Lordship.
No. 11th.
Item two.
May I please, your Lordship. Lordship, for a bail application, Lordship. Farcited case, Lordship.
You have taken steps.
Yes, Lordship, already.
I'm appealing.
You are appealing.
Yes, Lordship.
Kesari
Scan copy was called for, my lord,
and copy is there or no?
not received, my lord.
Lordship, actually, at the time of FIR, Lordship, victim girl was aged about 18 years, Lordship, as per school certificate, Lordship. And we got married, Lordship. Now victim girl is with me, Lordship, at my residence. And
Yes,
we have
what is
one
the
child
sub-
also, Lordship.
We have already made and have a little child, my lord. We are happy to
Child.
living.
Yes.
My lord, if-
Since when you are behind the bars?
From 7/8/2025, Lordship. Today is 28 days, Lordship, on the strength of NPW, Lordship. I was not aware about the case, Lordship, pending before the learned court below, Lordship.
Okay, heard Mr. T. Thakuria, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor, as well as Mr. D. K. T. K. Puya, learned counsel appearing for respondent number 2. This application under section 483 of BNSS has been filed by the petitioner, Shri Pratap Sarkar, who has been detained behind the bars since
8/8/2025.
8/8/2025 in connection with special POXO case number 87/2024 pending in the court of learned sessions judge, learned additional session judge cum special judge POXO Nogao. Learned counsel for the petitioner has submitted that on the basis of an FIR lodged on 27/2023 by the mother of the victim girl, the Kolyabad Police Station case number 65/2025 was registered under section 354/366/376 within bracket 2 within bracket N /385 read with section 6 of the POXO Act 2012. Learned counsel for this petitioner submits that after completion of the investigation, charge sheet was laid under what provision? Same,
Same, Lordship.
under the aforementioned provisions of law. He submitted that learned counsel for the petitioner further submits that the petitioner was unaware about the filing of the charge sheet. Why you failed to appear? You received summons.
Lordship, actually, though someone has been served, Lordship, that has not been received by me, Lordship, that has been received by my relatives, Lordship. That's why I am not aware, Lordship. about the-
Learned counsel for the petitioner has submitted that the petitioner was not aware about the date fixed in the trial court, as the summons were not received by him, but by his relatives. He also submits that the petitioner has been arrested on the strength of non-bailable warrant of arrest issued by the trial court. He also submits that in the meanwhile, the victim girl has been married to the petitioner and they have a child of
7 months old. Lordship.
7-month-old child after the said wedlock. He further submits that the petitioner is ready to face trial and shall cooperate in the trial. Stop. On the other hand, yes,
Otherwise, my lord, the birth certificate, school certificate also seized. As per the school certificate, 18 years, 3 months, but FIR shows that, my lord, 3 months ago. So, ekdam marginal it's on, my lord.
18 years.
on the other hand,
Na marginal, my lord.
the learned additional public prosecutor also submits fairly that the school certificate, that the certificate regarding age of the victim girl seized from the school shows that her age was 18 years 3 months
3 months. On the,
on the date of
FIR.
date of lodging of the FIR. Stop. Mr. T.K. Bhuya, learned counsel for the respondent number 2 submits that the victim has been married to the petitioner and has a 7-month-old child out of their wedlock. You have any objection? And the victim does not have any objection regarding grant of bail to the petitioner. Stop. Considering the submissions made by learned counsel for the parties, this court is of the view that if the petitioner cooperates in the trial, when is the next date fixed?
Next date, Lordship, 11/9/2025.
Cooperate in the trial. His custodial detention may not be necessary for fair completion of the trial of POCSO case number 87/2024. So, in view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned special judge POCSO, Nagaon.
Additional session. just
Learned additional session judge come, special judge POCSO, Nagaon, with following conditions. Trial condition, 2 trial condition. This bail application is accordingly disposed of.
Lordship, in victim has no objection. Instead of victim, Lordship, informant has no objection.
No, informant has no objection. Informant is the mother.
Mother.
Okay.
Master Lordship.
Lordship, the co-accused has already been granted bail yesterday. Here also, Lordship, 35(3) has not been followed.
Yeah, please,
BNSS
Lordship,
uh,
kindly pass over the method for timing. Mr. Cal is not there, Lordship. Mr. Cal will appear.
Let him appear. We'll take, okay, let him appear.
Yes, Lordship.
Item 4.
May I please, your lordship? It's a 483 bail application, your lordship. Dispute PSK 699 of 2025, your lordship, under section 143 subsection 3, 144 subsection 2 of BNS, your lordship, under along with section 5 of immoral trafficking.
Yes, there he would be required.
Yes, ma'am.
Third, Mr. What is your name?
AM Siddiqui.
AM Siddiqui. Learned counsel for the petitioner. Also, Mr. K.K. Parashar. Call for the case diary.
7.
Let this matter be listed on
Sure.
22nd September.
5.
Four eighty-three application, lordship. Sections are 65(1) and 6 of POSCO Act.
Heard Mr. U. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Let the case diary be called for.
Lordship, sir, seated.
Let the trial. What is your ground for seeking bail?
Lordship, already vital witnesses has been examined.
Okay. Let the scanned copy of the trial court records be called for. Let also notice be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 23rd of September.
That's it. Medical report.
It will come along.
It will be there. It will be there.
Item 6.
On a commercial quantity CDB.
Charge sheeted case.
No.
Heard Mr. A. M. Khan, learned, sorry. M. Khan, learned counsel for the petitioner. Also heard learned Mr. K. K. Parashar, learned additional public prosecutor. Call for the case. Diary.
23.
Let this matter be listed on 23rd of
Yes, sir.
September.
483 application lordship. FIR is at page 9 lordship. Offense under section 20B1C of NDPS Act lordship. Circuited case
Charge sheeted case.
lordship.
Heard Mr. A. K. Sakia, learned counsel for the petitioner. Also heard Mr. K. K. Parashar. Call for the scanned copy of the trial court records. Let this matter be listed
24th, my lord.
24th of September.
Deep level.
Item 8.
The petitioner is behind the bar as on today, 38 days. He approached the Ranit session judge, and session judge has rejected the bail application.
Pending investigation,
Yes, madam.
we'll call for the case diary.
So the lordship will kindly say for a moment, madam, page 22, he is suffering some incurable disease, madam.
What disease?
Lordship may kindly come to page 22.
Page number?
Page 22, madam,
It's again.
paragraph 2.
Yes.
So now immunity, he has very poor immunity, so now he is suffering from some illness also.
HIV one. What disease you are suffering from?
My lord, there are several other diseases, my lord, so immunity very, my lord, due to this, my lord, immunity becomes very low, my lord, now.
No. Whether you are given treatment in the jail, will issue direction.
Already there, my lord, in the order.
Order
itself,
is there,
The
but
superintendent central jail is directed to provide
Yes.
necessary medical.
yes.
So you are,
Last,
let the case diary be called. Heard Mr. N. Kolita, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Call for the case diary.
Some
Eight-
short date, my lord, because
18
38 days already, my lord.
18.
Because all offenses are 60 days offense.
15.
So can it be 11, my lord?
11.
10.
10.
Obliged. Item 9.
Here, my lord, with all respect, other matters are fixed on 9.
9.
my lord.
This also we will fix.
Same.
Heard
But
me.
another, my lord,
Yes,
sorry, my lord, can I, my lord?
yes.
We have taken, my lord, Babu Singh, my lord. Now it has come to our notice that WT to the residents in Mizoram and sent subsequently, violation of 48. And on the earlier occasion, I said, my lord, that, my lord, ladies engaged in flesh trade. I used the word license. That is wrong, my lord. But I have annexed the authority of the Apex Code, my lord, Basudev Kamaskar.
What
There-
it says.
There, my lord, Aadhaar card, everything, and despite existence of this Immoral Traffic Prevention Act 1956, my lord, quoted there, my lord. Now, ladies, my lord, who are in face trade, my lord, they are to be not harassed, even arrested, my lord. That direction is given. That is why nobody is arrested nowadays, my lord. That day I have to eat my words, my lord. I uttered, my lord,
Okay.
that was wrong, but my lord, that the tenor is exactly the same. That also we have put it. And lordship, may kindly, if possible, my lord, that my lord, violation of 48 is there, my lord, state may retro.
So we'll call case diary. It will be there.
Already called in fifth on
Exactly.
9.
It will be there whether.
That line is, if it is added, my lord, they will be furthermore equipped to do the homework.
Okay. Heard
Okay.
Mr. B. K. Mahajan, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned counsel for the petitioner has submitted that This is for the second time the petitioner is approaching this court seeking his bail. He submits that this time he has taken an additional ground regarding non-compliance of procedural requirement as provided under section 48 of the BNSS. He also submits that some connected matters of other co-accused are fixed on 9th
No, we do. I didn't.
9th of 9th of September, and therefore prays for listing this matter along with the said cases. The prayer is allowed. Let the case diary be called for. Let this matter be listed on 9th of September.
Highly available.
Item 10.
If there's a lot of, there's a regular bail application. FIR is at page 15. Sum and substance of the allegation is that beef meat was found in my car. I happen to be a driver. I was going to Aizol, taking frozen meat. I was told to deliver to frozen meat, which I was given the impression that is chicken, and I was supposed to deliver it in Aizol for KFC. Then I was apprehended in.
What is the quantity?
Well, the quantity, if your lordship comes to page 16. 30 brown cartoons, suspected beef. They have
30.
not given the weight exactly, but 30 cartoons.
30 cartons.
30. I was supposed to deliver it to Aizol for KFC. I happen to be only the driver.
Yes, Mr. Parashar.
To Aizol, but
We are fixing a short date for
Yeah,
the court case.
I'll be of that.
Heard Mr. H. K. Nath,
Jai Bora.
sorry, heard Mr. J. Bora, learned counsel for the petitioner. Also heard Mr. K. K. Parashar. Call for the case and let this matter be listed on 15th of
maybe 16, 3 days, 4 days is close, 12, 13, 15.
16th of September.
16.
Obliged.
Item 11.
Made, Mr. Lordship. Lordship had 483 application, my lord. FIR page 18, 3 petitioners, my lord. The allegation is that some immoral prostitution business was going on in the hotel, but the petitioners,
Also
my
is
lord,
there.
they are innocent person, my lord. There is no allegation against the petitioner. My lord, may I take my lord?
Why the trial court rejected your prayer? Where is the rejection order?
Rejection, I have not yet got the certificate, my lord.
That is required.
But otherwise, my lord, page 19, the FIR itself is clear, my lord.
No.
Page 19.
No, but why the trial court has rejected your prayer? You have approached the trial court or not?
I have
So that rejection order has to be there. You annex the rejection order. You have to annex because
In the forwarding report, it is mentioned that during investigation revealed that the accused persons involved in prostitution business. That is there.
it is pending investigation.
Yes, sir.
It is, my lord, page 19.
Heard Mr. M. R. Khandekar, learned counsel for the petitioners. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Perusal of the case diary is felt necessary for consideration of the instant bail application. Hence, let the case diary be called for. Let also notice be issued to you have filed Vakalatnama. Mr. R. Islam has appeared for the respondent. Who is the respondent number 2? Respondent
There are
number 3.
15.
2, then 2.
Heard Mr. R. Islam, who appears for respondent number 3 and 4. What is your submission? I am not hearing anything. You have to be louder.
Lordship, I am submitting that after annexing the rejection order, I will submit, Lordship.
Okay. file the rejection order
And
before the next
in the
week.
meantime, City may be called for.
Yes. The learned counsel for the petitioner has prayed for allowing the petitioner to file an additional affidavit to bring on record the bail rejection order of the trial court. The prayer is allowed. Let this matter be listed on 9.
For as number 2, I can appear also. He is the inspector of police. Otherwise, as well as. And then services public.
As learned additional public prosecutor has appeared for respondent number 1 and 2, no formal notice need to be issued, and service of notice on all respondent is held to be complete. Let this matter be listed on
Runs 15, my lord.
15th. Okay.
I am leaving.
Regular bail petition, page 11 is the my lord. FIR. This regarding my lord, illegal mining of Umrang mine. Page 11.
Where is the rejection order?
My lord, rejection, my lord. Page 21 onward. My lord, prior to that, my lord, poetry approached this honorable court. Almost all of them were granted bail, my lord. I have annexed an order.
But why your prayer was rejected?
Rejected lordship,
What is your name? Jamal Ali.
Kamal Ali.
Page 28, second paragraph, allegation against the, after all, 9 people died in the, while working in the, this mining holes.
Who are you?
My lord, I am manager of lordship, it is in the forwarding report itself, my lord.
We are fixing a short date.
My lord, page,
Since when you are behind the bars?
my lord, from 23/8/25. He is not FIR named accused, my lord, and he is not, we are connected with the illegal mining. He is an employee of this Pijus Munisha, my lord.
But your prayer was rejected after perusal of the case diary. So perusal of the case diary would be necessary.
17, my lord.
Heard Mr. I. Laskar,
Yes,
J. Laskar, learned counsel for the petitioner. Also heard Mr. K. Parashar. Call for the case diary. Let this matter be
17,
listed
my lord.
on 17th of September.
a court is bill lordship earlier granted.
On 17th, we will consider.
My lord. Of like 54.
Made please, ma'am. Bail application under section 483 of the BNS. I am behind the bar since the last 30 days, ma'am. Earlier, I had approached, I had filed an anticipatory bail application, my lord, that had become infructuous because during the pendency of the said anticipatory bail application, I was arrested, my lord.
What is the offense?
My lord, offences are, my lord, 189(2) unlawful assembly, 117 subsection 2 voluntarily causing grievous hurt, 351(3) criminal intimidation.
We are calling for the case diary.
Deeply obliged.
Heard Mr. P. R. Sharma, learned counsel for the petitioner. Also heard Mr. K. Parashar. Let this matter be call for the case diary. Let
Short
this
date may
matter-
kindly be fixed. 30 days already I am behind the bar. 17, ma'am.
17.
Deeply obliged.
Item 12.
May please, my lord, lordship pass over for the deputy to conducting counsel Mr. Wayne and other.
Okay.
Item 14.
Made please, your lordship. My lord, the petitioner is working as a drug inspector, my lord, under regulation 3F. Now, my lord, there is a brief background in this case, my lord. Government had issued an office memorandum on 16/3/2015 that whosoever has put in 12 to 22, 9 to 22 years of service under 3F, their engagement will be regularized. Now, my lord, along with this present petitioner and another person called Purnasindhu Mudoi,
and some other from the Social Welfare Department, my lord, filed writ petition before this honorable court, praying for regularization of their services. Now, my lord, as far as the other departments are concerned, their services have been regularized based on the order of this honorable court. Now, my lord, as far as the present petitioner is concerned, if your lordship would kindly come to page number, the order in the writ petition, my lord, page number 111. Para 17. Earlier, my case was rejected, my lord. Then I approached this honorable court. Then para 17 is the operative direction. Under such circumstances, this court is of the considered view that matter will require fresh consideration in the hands of the government for considering the case of the petitioner for regularization in terms of the OM dated 16th of March 2015. Government will examine the case of the petitioner as also contention raised before this court that several incumbents were regularized, were given the benefit of regularization under OM dated 16/3/15, did not fulfill the criteria, but nevertheless the benefit of regularization was confirmed. Well, after this order, what had happened, my lord? In our place, my lord, some other incumbents were brought in, and we were left without any, my lord, posting. Then, my lord, we filed a writ petition. This honorable court protected us. Now, my lord, there is a third.
Where are you posted now?
Now, presently, I'm in Guwahati, my lord, as drug inspector under 3F.
Okay.
Now, my lord, finally, my lord, another order has been passed, which your lordship will get. I'll come to the criminality part, my lord. Page 140, my lord. This is the last in point of time. Para 22. However, since the petitioners were appointed as under Regulation 3F by the state, and they have continued to render services for more than 20 years since their date of initial appointment in the year of 2005, and their services being extended periodically by the state, and also in absence of any explanation on behalf of the state as to why the cases of the petitioners were allowed to be continued under Regulation 3F without any proposal for regularizing their services, the petitioners shall not be terminated from their service till such time department takes a decision in the matter in terms of the relevant rules as well as provisions of the rules of 1951. So this is the direction. Now, my lord, situated thus, the other petitioner, Purno Hindu Mudoi, against him also, my lord, similar case of disproportionate asset was, my lord, registered. If your lordship would kindly come to page 142. If your lordship would kindly come to page 144. Para 6, 7, and 8, my lord. I have considered the submission made by the learned counsel for both sides. Though the accusation against the petitioner is having assets disproportionate to his known source of income there in this case, however, it appears that he has been cooperating in the investigation, in the regular inquiry as well as investigation, and there is no basis of speculating that he may not cooperate in the investigation. He may flee away from his course of justice. Even if any such apprehension is there, same may be addressed by imposing appropriate condition while granting anticipatory bail to the petitioner. Since the petitioner has been appearing regularly and is ready to continue to appear before the investigating officer and cooperate in the investigation, his custodial interrogation may not be necessary if he cooperates in the investigation. The ad interim bail was, my lord, made absent. So this is the other petitioner. There is a Purno Hindu Mudoi. Now please come to the inquiry report in this case, my lord, at page number 60. My lord, the property which was gifted to my father, that also has been taken note of. Please come to page number 59, my lord. Same case as like Purno Hindu Mudoi. During inquiry, it is found that income of SO, para 6.15 at page 50. During inquiry, it is found that income of SO, Mr. Pankaj Kakoti and his wife, Mona Lisa Talukdar Kakoti, from also legal sources is 1 crore 40 lakhs and all. And expenditure is approximate to the tune of 98 lakhs. Thus, his likely savings is 42 lakhs. Against this likely savings of 42 lakhs and odd, He possesses assets worth 1 crore 43 lakhs. Thus, he possesses disproportionate. Well, here also, my lord, they have committed a mistake in, my lord, deducting. Now, what had happened, my lord? Two property which my father, actually, my lord, there is a plot of land. Now, in that plot of land belongs to my father. My father gave it to a developer to develop the property. After that, my lord, 2 flat was gifted to me. Those who give this, my lord, we have annexed, that also have been taken note of to arrive at this figure. Page number 43, my lord. Page number 43.
Yes.
3 and 4, my lord. Purchase a flat at first floor at a residential building known as Louis Awas, situated at Betkusi. Serial number 4. Purchase a flat at first floor at residential building known as Louis Awas, situated at Betkusi. Now please come to page 68, my lord. This is a registered deed of gift by my father. And this land belongs to
This
my
is in
father.
respect of these 2 flats.
Yes, these 2 flat, my lord. Page 69 is the, page 68 is the one deed gift, my lord, registered. So where is the question of my purchasing? My lord, because I am seeking regularization, that's why might as well, my lord, trouble them. At page 73 is the second gift deed, registered deed of gift. Kamal Chandra Kotoki, that is the father, and Pankaj Kakoti. And these 2 have also been included. In any case, my lord, these are matters to be gone into at this stage of trial. My lord, kindly see, my lord, the circumstance, the attending facts and circumstances. I'll cooperate, my lord, in the similar situation. My colleague, my lord, Purna Hindu Mudoi was given interim bail, and subsequently his interim bail was made absent. And I'll cooperate, my lord.
No, you cooperated in the regular inquiry.
Of course.
Now, why are you apprehending?
Page number 80, my lord. And I was present when the charge was conducted. Kindly see on left hand side is my signature. I'll cooperate.
No, why are you apprehending them?
Well, these are all non-bailable offences, my lord.
Have they given any indication that you may be arrested?
Well, I'm apprehending, because kindly see, my lord, end of the day, these are cases just because I'm claiming my regularization. All other petitioners have been regularized, health department has not done. Social welfare department and other departments have done it. A series of cases going on since 2014. And my lord, the punishment of 10 years is also there. Therefore, my lord, that 41A aspect will also not come. Now 35(3). And
Yes,
similar
yes,
situation,
yes.
my lord, Lordship has already given the benefit.
Yes, Mr. Kotham.
Your lordship will find that in this case, the question of apprehension doesn't arise. We have already.
What is the punishment?
Punishment up 10 years.
More than 7 years.
Yes, more
More than some, that is understandable because it's basically a case of documentation. Documents have been seized. And the IO, my lord, after comparing the documents, if they found, because sources known to the prosecution.
You don't require their apprehension, his apprehension.
The question of apprehension doesn't arise, my lord. It is the prerogative of the investigating officer after going through the documents made available to him, his income, assets, and it is found to be disputed, he will file such it, my lord. Nothing, and he will obtain sanction from the appropriate authority and he will file such it. So it is a question of apprehension.
Is he cooperating?
We have not issued any notice to him as of today, my lord, because he already appeared before the inquiry officer.
Then we'll dispose of this anticipatory bail if you don't intend to arrest. He will cooperate.
So that part, I have to take instruction, or because at present I don't have the case diary with me, whether he intends to
Okay, then
examine.
bring the case diary.
I will bring the case diary.
Heard Mr. K. N. Chaudhary, learned senior counsel assisted by Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. Mr. P. Kotoki, learned special public prosecutor, CM Vigilance Cell. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Pankaj Kakoti, who is apprehending his arrest in connection with Vigilance PS case number 22/2025 under section 13 within bracket 1 within bracket small b /13 within bracket 2 and /12 of the Prevention of Corruption Act 1988. Where is the FIR?
Yes. FIR is at page number 61.
The gist of accusation in this case is that
The relevant person is at 64.
that on 1/7/2025, one Alongbar Basumatari, Inspector of Police of CM Vigilance Cell, had lodged an FIR before the officer in charge of page number 61.
It starts at 61, my lord. The operative portion is at 64.
Vigilance Police Station, inter alia, alleging that the present petitioner has amassed disproportionate asset and has found possessing asset which is disproportionate to his known source of income. Before it is also alleged in the FIR. No, 60 is not the starting point of.
64, my lord. 64, my lord.
64. Yes, sir.
Form is in heavy. 62. 64, my lord.
Date of FIR change for 29/8/2025.
29/8/25.
It is stated in the FIR that before filing of the FIR, a detailed vigilance inquiry was conducted bearing RE number 13/2025, where and during the said inquiry, sufficient materials were found indicating to the disproportionate assets possessed by the petitioner disproportionate to his known source of income. Learned senior counsel for the petitioner has submitted that the petitioner has cooperated in regular inquiry and shall cooperate in the investigation also. However, as non-bailable offenses are involved, which entails punishment up to 10 years of imprisonment, he apprehends that in such case, as no notice under section 35(3) is required to be given, he may be arrested. He also submits that on perusal of the FIR regular inquiry report, it appears that the computation of there has been wrong computation in calculating the assets of the petitioner, in as much as one plot of land which belongs to the father of the petitioner, as well as 2 flats which the petitioner received in gift, has been shown as purchased by the petitioner. Stop. Your submission is regarding vindictive prosecution.
Yes.
That is required to be reflected.
The whole thing is because we are
On
asserting our right, they want
Stop.
to teach us a lesson.
on the other hand, learned special public prosecutor has submitted that there is no apprehension of petitioners getting arrested in this case. And therefore, an application under section 482 is not maintainable. He submits that petitioner has cooperated in regular inquiry. Cooperated in regular inquiry. However, he also submits that the case diary may be called for. Stop. Let the case diary be called for. Fixing 23rd September for case diary. In the meanwhile,
23rd.
learned special public prosecutor Agod Dibak also opposed grant of any interim protection to the petitioner at this stage. Stop. Let the case diary be called for. However, in the meanwhile, considering the submissions made by learned senior counsel for the petitioner, as discussed in the foregoing paragraphs, the petitioner is directed to appear before the investigating officer of Vigilance Police case number 22/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one security of like amount, subject to the satisfaction of the arresting authority. List as directed.
Diplomat.
14.
Yeah, Lordship, also is there. So notice may go, Lordship, and in fact, Lordship, police officer is the informant. I think my friend can take the notice in respect of the respondent number 2 also.
No, you don't know who is the victim or victim's parent.
Lordship, as per allegation, there are 2 victims. And in the hotel, Lordship, some incident was taken place as per the allegation. And the police officer has lost the paper.
No, notice to police officer will not go. Notice to victim or guardian of the victim or support person. Who is the victim? Where is the address of the victim?
Lordship, FIR is at page 10. Last 2 lines, 3-4 lines, Lordship. We arrived at on interrogation. The names of victim have been learned as Azmira Begum.
Where are you reading?
Page 10, It's the
Last 3 paragraphs.
on interrogation, the names of victim have been learned as Azmira Begum, so and so, and Mihirun Nessa.
They have to be pleaded as party.
As
The
per,
pay-
as
the-
per allegation, Mihirun Nessa was the Lordship, was below 18 years. Mihirun, next page, page 12, your Lordship will find.
Whether Ismail Hussain is,
If you Lordship direct, I will take a step and I will submit the Lordship, amended post title Lordship.
heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. It appears that this case involves offense under POCSO Act. However, the respondent number 2 in this case is the informant who is a police officer. Stop. There is a requirement. No, Deepak Nayak is
Deepak
division
Nayak.
bench or
Yes, sir, Deepak Naik case also, the victims should be heard, and
in the case of Deepak Naik versus State of Assam, an observation was made that in cases involving offense under POCSO Act, notice to the victim slash guardian of the victim slash support person has to go. It appears that the address of the victim girls are mentioned. It appears that there are two victims shown in the FIR and their address have been stated in the FIR itself. The petitioner is directed to implead both the victim girls as party, as respondents in this case. They-
One is, my lord,
One is major.
25 years has been given. There's 10, last two lines, my lord, has been 25. Second victim is 17 years.
Is 12. Continue.
Second victim, my lord, first line of page 12, my lord.
No, but no separate case was registered.
Yes, yes. my lord.
So both the victims, you make both the victims as party. Learned counsel for the, no, the petitioner is directed to file an amended cause title after impleading the victims as respondents in this bail application. They shall do so. He shall do so within a period of 7 days. 7 days from the day.
Positive or Monday will. Let's see.
11th, before 11,
Yes.
before next date fix.
11.
Let this case be listed on 11th of September.
Item 15.
Yeah, please, Your Lordship. My lord, in this case, my lord, petitioner is an ex-army personnel, my lord, and he rented the vehicle to some persons, my lord, and subsequently vehicle was collided in a with the pond, my lord, and then in his vehicle, my lord, 23.83 gram of heroin was recovered. Your Lordship may kindly found it. FIR is at page, my lord, start from page 11, my lord, and page 15 is the FIR, my lord.
Yes.
This is to inform you that today, 9/8/2025, at about 4:50 PM, on one information received was Sunai PS over telephone from Head Constable Nuruddin Mazumdar of Sunai. As per information, one vehicle bearing number AS11J 0245, which was falling down into the pond of Custodial Part 2, has been recovered, and the driver and co-passengers of the vehicle had fled away from the spot, and also informed that he noticed some suspected narcotic substances inside the above mentioned vehicle. Accordingly, general ID entry was made by me as officer in charge of Sunai PS, byte number such and such. On receipt of the information.
What was found?
My lord,
What contraband was found?
that is my lord, para 4, my lord. Recovered suspected heroin,
How much?
23.83 grams.
Now, what is your case?
My lord, I am my lord, retired army personnel, my lord. And my vehicle was had by the accused person, unknown accused persons, my lord, because, my lord, I have also annexed the, they have payment receipt, my lord, at page 26, your lordship may found. That is, his name is Abdul Haq Majumdar. On rental basis, my lord, he had my vehicle.
What is the date of incident?
Date of incident is at 8/9/2025.
When the vehicle was hired?
Vehicle was had, my lord, prior to, from almost 1 year, my lord. And I have also stated in this, my lord. And none of the, I have also not named in the FIR, my lord. And
Then why are you apprehending your arrest?
my lord, I am apprehending because, my lord, since, my lord, the contraband found 23.83, it is less than 10 years, my lord, I may be arrested. And in the event of your lordship allow me, I will also provide with the police, my lord.
Yes.
And I am also a
ex-army personnel, my lord. I have also given the details.
FIR of August, and he has annexed a money receipt, bank statement. It is of May.
27/5/25.
No, why are you apprehending this?
Since my lord, I am owner of the vehicle, my lord.
Police has not tried to arrest you till now.
My lord, no, my lord,
Then we'll fix a short date and call for the case then.
my lord. In the meantime, I may be protected, my lord. At least I will appear before the police, my lord, so that police
Heard.
offer investigation further.
Heard,
investigation.
Mr. E. Alam,
I allow.
I. Alam, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of the NSS has been filed by the petitioner Samir Uddin Majumdar, who is apprehending his arrest in connection with Sonai PS case number 57/2025 under section 21B of the NDPS Act. The gist of accusation in this case is that on 9/8/2025, one Vishwajit Nath, SI of police, had lodged an FIR before the officer in charge of Sonai police station, inter alia alleging that on that day at about 4:50 p.m. an information was received regarding the fact that one vehicle bearing registration number AS01
Yes, 11, my lord.
AS11J02545 had fell into a pond and stopped. When the same was recovered from the pond, the driver and co-passengers fled away. Stopped. During search of the said vehicle, 23.83 grams of suspected heroin was recovered therefrom. Learned counsel for the petitioner has submitted that the petitioner is the owner of the vehicle from where the seized contraband was recovered. He, however, submits that the petitioner is in no way involved in the offense alleged in the FIR. He submits that the petitioner is a ex-serviceman from defense forces. He also submits that though he is the owner of the vehicle, he had given the said vehicle on rent to
Abdul Haq Majumdar, my lord. That is-
Abdul Haq Majumdar, and he was unaware that his vehicle was used, that his vehicle was used in commission of illegal acts. In support of his submission, he has submitted, what is this, bank statement?
Bank statement, my lord.
Bank statement, which indicate that he has received rupees 20,000 on $20,000 from Mr. Abdul Haq Majumdar as rent. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Let the case diary be called for. Let this case be listed on 17th of September. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in foregoing paragraphs, the above named petitioner is directed to appear before the investigating officer of Sonai PS case number 57/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with above noted case, he shall be allowed to go on interim bail of ₹30,000 with one surety of like amount. Yes, instead of 17th, 24th of September, list accordingly.
Obliged.
Map is lost. Not the FI, my lord. That is 14, my lord. It's 15.
What is the offense?
Offense, my lord, forgery, my lord.
Forgery of?
Forgery of document. Here, my lord, one Aryan Kumar, my lord, he appeared in
Who are you? What is your name?
My lord, my name is, my lord, I am no way involved in the FIR also, my lord. There is nothing against me, my lord. Just one information that the prime accused, my lord, he instructed the candidate to make contact with the petitioner. This is the only whisper in the FIR. The prime accused was arrested.
No, what is the accusation? What?
Accusation, my lord, one Aryan Kumar, my lord, he was selected, my lord, in CIS, my lord. And his PRC was submitted, forwarded for police verification. Then, my lord, it was suspected. Then Aryan was called, my lord, and he, my lord, went to my lord office. Then during investigation, my lord, he named one Pinku Sohan, my lord, that he obtained certificate through Pinku Sohan. Thereafter, my lord, they suspected. And Pinku, my lord, instructed that he, my lord, page 15, that according to my lord, candidate, my lord, Pinku instructed to make communication with this petitioner. And Gaubura was also issued certificate. He was also arrested. And
No, where is your involvement?
nothing, my lord.
No, you show me in the FIR.
Only just one. My name is recorded in paragraph 2, my lord.
There are two
After
at page
15. After interrogation, as per statement of so-and-so, stated that he has taken PRC from so-and-so. Anand has put him to touch with Pinku Sohan and Jitendra Sohan. Jitendra Sohan is the petitioner, my lord. So and the prime accused was arrested, Gaubur was also arrested, candidate was also arrested. Subsequently, they were released on bail. Now, my lord, police is charging me, my lord. All document has been seized.
6 lakhs were given to 3 persons. Among those 3 persons, he is one of them. And people.
Money transaction, my lord, I have given, my lord, page 22. No transaction with the petitioner.
51 numbers of certificates.
Where do you stay?
My lord, who's I, my lord?
51 numbers.
I'm a local, my lord. I'm a contractor by profession.
We are fixing short day.
I am a contractor, my lord. There is no whisper, my lord. And the transaction I have given, police seized the transaction, my lord. There is no transaction with the petitioner. Page 22, my lord. This is also from the record, my lord, court record, my lord. And some transaction with the Pinku Sohan.
Heard.
I'll cooperate, my lord.
Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Considering the nature of accusation leveled in the FIR, perusal of the case diary is felt necessary for consideration of the instant bail anticipatory bail application. Hence call for the same. Short. List this matter on 17th September.
Item 17. Similar, my lord. Here, my lord, the petition is Anand Kumar, my lord. He is from UP.
17
Lordship.
September, same order.
And he is from UP, my lord. He has no rule, my lord.
Same orders on 17th.
18 also, my lord.
18 also same order.
Item 19.
Meet Pizza Lodge. Lordship has gone to the FIR in item number 10. Some frozen meat was seized. The vehicle has been taken into custody. The driver is in custody. The goods have been seized. My only role was that I am the owner of the vehicle. So my apprehension is that I might be arrested in this connection. So Lordship.
Oh, why are you apprehending?
Because when my younger son went to the police station in Silchar, he was asked to call me to the police station. And police has been looking for me.
What order has been passed in item number 10?
Lordship may just give me protection till the
Where do you stay?
Lokhral. Go ahead. I'll cooperate with the I'm only the owner of the car. I am not a named accused in the FIR. My son has already been arrested.
Your son has been arrested.
He was a driver in the city. Lordship may give me protection till the CD is. It's only frozen meat, Lordship.
What else is your submission?
None of the sections are attracted towards me, Your Lordship. I'm not a named accused. It was frozen meat, Your Lordship.
You wait till 11th.
She may just give me protection till.
Heard Miss T. Parashar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Ramesh Ray. No, you don't have any knowledge about using your vehicle.
I have no knowledge about what purpose it was being used for. I bought it for my son who was not working and gave it for him to earn his livelihood, Lordship.
Ramesh Ray, who is apprehending his arrest in connection with Silchar PS case number 868/2025 under section 303 within bracket 2/317 within bracket 2/318 within bracket 4/325 of BNS read with section 13 within bracket 1 of Assam Cattle Preservation Act. The gist of accusation in this case, where is the FIR?
FIR is at page 14, Lordship. The
Gist of accusation in this case is that on 30/8/2025, one Arindam Bhardwaj, SIF police, had lodged an FIR before the officer in charge of Silchar police station, inter alia, alleging that one vehicle bearing registration number AS01QC 6995 was intercepted and was suspected to carry beef meats in brown cartons in violation of provisions of Assam Cattle Preservation Act 2021. Learned counsel for the petitioner has submitted that the petitioner is the registered owner of the vehicle from which the suspected beef meat was recovered. She submits that though the petitioner is the registered owner of the vehicle was used for his livelihood by his son, who is also the driver of the said vehicle, namely Surajit Roy. Surajit Roy is your son,
Yes, Your Lordship.
namely Surajit Roy, who has already been arrested in connection with this case. She submits that the petitioner is in no way involved in the offense alleged in the case, except for the fact that he happens to be the driver of the vehicle. However, as his son has been arrested and as the police is searching for him also, he is apprehending that he may be arrested in connection with the aforesaid case. She further submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has submitted that in a connected case, the case diary has already been called for fixing 16/9/2025 for the case diary. Hence, he prays for fixing this case also on 16/9. Let the case diary be called for. Let this case be listed on 16/9/2025. Stop. However, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraph, in the meanwhile, before arrival of the case diary, if the petitioner is arrested in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed accordingly, 116.
Lordship, in a similar case, Lordship, same affair, CD is fixed on 8/9/25, this coming Monday, Lordship. So, this
We'll fix it. What is your name?
F inter, Lordship.
Item number? Third, Miss F. Intaz, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Learned counsel for the petitioner submits that in a connected case, that is bail application number
2070 of
2070. AB number 2070 of 2025. Case diary has been called for and the case is fixed on 8th of
8/9.
8th of September. She submits that this case may also be listed along with the same case, said case. The prayer is allowed. Let the case diary be called for. Let this matter be listed along with the above mentioned case on 8th of September 2020.
Okay.
21.
The 482 application notice. Notice FIR is in page number 10. Lordship. The second time I am filing with you. Page number 10. Lordship. So can I read it?
This is your second bail app.
Yes, yes, Lordship.
First one,
For the retake, Lordship, the order is in Lordship, page number 19, Lordship.
why it was rejected?
Nine.
Now what new grounds?
Lordship, when the incident occurred, Lordship, Lordship present, Lordship, at that time, Lordship. Lordship, but he was not involved in anything, Lordship. Lordship, his shop is near where the incident occurred, Lordship. He has a motor parts shop, Lordship. Lordship, he came out from his shop, Lordship, after closing, Lordship. Then he saw, Lordship, that some of his Lordship, he knows that person, Lordship, who are fighting, Lordship. They were local persons, Lordship. He only knows them, Lordship. But only thing is that, Lordship, he just stopped them not to fight, Lordship. And when some were arrested.
No, but these facts were considered earlier. Earlier also it was considered. For moving a second anticipatory bail application, you have to show some new ground. Or we call for the case diary. Heard. Mr. What is your name?
SKSN Mohammed, Lordship.
SN Mohammed, London Counsel for the petitioner. Also heard Mr. KK Parashar. Let the case diary be called for 19th. Let this case be listed on 19th of September. You have to show new grounds on that day.
Okay, Lord. And we have 12. Okay, sir.
Yes.
My lord, this anticipatory bail application, the FIR your lordship will find the relevant portion at page number 17.
Page number?
17. Your lordship. Initially, a complaint was registered before the deputy commissioner. It was converted into a FIR on the basis of a complaint received from the office of the police.
What is the accusation?
Yes, the allegation is that there is a scheme under the NRHM, your lordship, called the Janani Suraksha Yojana. Under that scheme, your lordship, during childbirth, certain amounts are granted to pregnant women by the NRHM, your lordship, to assist during that process. The allegation is that this one lady, Krishna Devi, she has been taking money from the NRHM on the pretext under this scheme and depositing it in the accounts of lordship will kindly see the allegation at page, last paragraph at page number 17. Accounts of women who are otherwise not pregnant, and this amount then she is later taking from them, she is giving them 300 rupees. I am not Krishna Devi. Lordship will see the last part. Shockingly, she collected 1800 out of 2100 from every woman, leaving only 300 with the account holder. In this manner, she misused the JSY scheme and cheated almost all women in our village. The victims include college students like me, widows, non-pregnant women, and elderly women, none of whom are eligible for the JSY scheme. In this case, what has happened?
The scheme is only for pregnant women.
Only for pregnant women. I have received some money in my account, your lordship. My account, I have the statements are there on record. But I am not the accused. Now, the police, your lordship.
No, who are you?
I am a
You may be
beneficiary who have received certain 2100.
But you are a lady.
I am a lady. I have received some money in my
Have
account.
you been pregnant?
Not at that time.
So you are also an accomplice.
Lordship will kindly see, they are poor village women. When somebody comes up to them and says there is a government scheme, there are so many schemes around.
Get 300 rupees.
300 rupees. For that 300 rupees they have, and we have given this lady the cash, the rest of the amount. That is the extent of our involvement. So now the police has all had picked up my younger brother and then released him. So I am under apprehension that I will be taken into custody. I am willing to otherwise cooperate with the investigation.
Yes, Mr. Parashar. So main culprit is Krishna. Heard Mr. KP Pathak, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Sabina Yasmin, who is apprehending her arrest in connection with Mikir Bhetta PS case number 107/2025 under section 316 within bracket 2/318 within bracket 4/319 within bracket 2 of BNS. The gist of accusation in this case is that on 19/8/2025, one Munmi Devi had filed a complaint before the Deputy Commissioner of Morigao District, inter alia, alleging that one Trishna Devi has been cheating innocent villagers by giving false information regarding about a government scheme. Stop. It is also alleged that the said Krishna Devi had collected had misused the government scheme, namely Janani Suraksha Yojana within bracket JSY, which is only meant for pregnant mothers for safe delivery. It was alleged in the affair that the money out of the said scheme was deposited in the name of villagers who are women, innocent women and students who are not eligible to get, one not pregnant and not eligible to get benefit from the said scheme. It is also alleged that out of the total amount of 2100 deposited in the account of every beneficiary, said Krishna Devi collected 1800 and leaving only rupees 300 in the account of the beneficiary. Learned counsel for the petitioner has submitted that the petitioner is the victim of is in fact a victim in this case. She was also duped by the main accused Krishna Devi, and her account was used to deposit money out of Janani Suraksha Yojana. From your account also, Krishna Devi.
I had given her that amount in cash.
Thereafter, the said a major share of that money has been deposited, has been given to the main accused Krishna Devi by the petitioner. Stop. Learned counsel for the petitioner submits that the petitioner is not named in the FIR, and on perusal of the FIR itself would reveal that it is Krishna Devi who is the main accused in this case. However, when the brother of who went to the police station,
The younger brother was picked up by the police station.
however, the police had picked up he's arrested.
He's not
was
arrested. He was released.
picked up the younger brother of the present petitioner and asked him to produce the petitioner in the police station, which has led to the apprehension that the petitioner may be arrested in this case. Supplemental counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation. However, unless some protection is granted to the petitioner, she apprehends that she may be arrested in this case. On the other hand, learned additional public prosecutor submits that considering the nature of accusation level in the FIR, case diary may be called for. Stop. Let the case diary be called for. Let this case be listed on 23rd of September. In the meanwhile, however, considering the submissions of the Learned counsel for the petitioner as discussed in the foregoing paragraphs. The petitioner is directed to appear before the investigating officer of Mikir Bhetta PS case number 107/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If she does so within the stipulated period of time, in the event of her arrest in connection with the aforesaid case, she shall be granted interim bail of rupees 30,000 with to the satisfaction of the arresting authority with following conditions 1 and 2, list accordingly.
Item 55 from supplementary list. Make me.
Yes.
Now, there's an application praying for transit interim bail matters. Now, an FIR has been registered in the state of Karnataka under section 66 C and D of the IT Act and section 318B of the BNSF.
When will you go to
2
Karnataka?
weeks, my lord. The petition is 19 years old.
But while mentioning the matter, the council said that you will go to Karnataka on Monday.
Next week, I'm planning, my lord. Kindly protect us for 2 weeks.
Why 2
In-
weeks?
In case, my lord, it's very far off, my lord. The petition is from Narayanpur, Lakhimpur, my lord. Since 19-year-old, my lord. He's gathering funds and he'll appear before the jurisdictional court, my lord. Similar orders have been passed earlier, my lord, by this honorable court, my lord.
In this case,
Not this case, my lord. Similar, my lord, transit application, my lord, bail application, where 2 weeks' time was granted to appear before the jurisdictional court.
Otherwise not on.
why are you apprehending?
My lords, a 35-3 notice was sent through the Narayanpur police, my lords, and the time has passed, my lords. I was supposed to appear within 7 days from receipt of the notice, which was 21/8/25, and thereafter, my
Heard
lord, the
Mr.
police.
P. Mohanta,
I'm very grateful.
learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner who is apprehending his arrest in connection with Vijayapura Police Station crime number 0047/2025 under section 66D/6060C of the Information Technology Act, as well as under section 318 within bracket 4 of the BNSS. Learned counsel for the petitioner has submitted that the petitioner is a resident of
Narayanpur in the district of Lakhimpur.
Narayanpur in the district of Lakhimpur. However, he had received a notice under section 35 within bracket 3 of BNSS from Cyber Economic and Narcotic Crime Police Station, Vijayapur in the state of Karnataka. State of Karnataka, whereby he was asked to appear before the investigating officer of crime number 47/2025 on when you were asked to appear within 7 days.
Within
from-
7 days, the date of the notice is 21/8, my lords.
Within 7 days from the date of receipt of the notice. When you have received the notice,
22nd, my lords. 20.
on 20. Learned counsel for the petitioner has submitted that the petitioner had received the aforesaid notice on 22nd of August 2025. What is the date of the notice?
The notice is dated 21/8/25, my lords.
On the next day you receive notice
Like it must have been sent
by
electronically,
WhatsApp.
my lords. Station, my lords.
However, he submits that the petitioner, the time granted in the said notice, time of the 7 days granted in the said notice has lapsed. And therefore, petitioner now apprehends that if he approach the investigating officer of the aforesaid case now, he may be apprehended in the said case. Learned counsel for the petitioner also submits that as the case, aforesaid case is pending in a police station in the state of Karnataka, he needs some time. Ingorani Asin. Some time to appear before some time to approach the jurisdictional court to seek necessary relief in the aforementioned case. Stop. Learned additional public prosecutor raised no objection to grant of limited protection to the petitioner in terms of the guidelines of the apex court in the case of Priya Indoria versus State of Karnataka and others, reported in 2024 4 SCC /749. Stop. Considering the submissions made by learned counsel for both sides and after perusal of the materials on record, this court is of considered opinion that since the time mentioned in the notice under section 35 within bracket 3 received by the petitioner has lapsed, the apprehension of getting arrested and the apprehension of the petitioner of getting arrested in connection with the aforesaid case appears to be genuine. Stop. Since the aforesaid case is pending in a police station in the state of Karnataka, this is a fit case where limited transit bail may be granted to the petitioner in terms of the guidelines of the apex court in the case of Priya Indoria versus State of Karnataka and other supra. In view of above, this court is of considered opinion that how much 2 weeks time?
Which will suffice, my lord.
2 weeks date at Anyok. Which date? Till
You have to- Excluding today.
in view of above, the petitioner is granted interim transit bail to till 25th of September. Stop. 25th of September 2025. We enable him to approach the jurisdictional court to seek appropriate relief. Stop. Stop. In view of above, if before the said period, the petitioner is arrested in connection with above mentioned case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number 1 and number 2. It is hereby made clear that the relief granted in this case is interim in nature and will remain effective only till 25/9/2025. This this anticipatory bail application is accordingly disposed of.
One correction, my lord, my sincere apologies, my lord. If my lord peruses page 11 of the notice, my lord, it is in the month of August, but the date is not mentioned. But my lord, in my pleadings, I have stated that it was served upon me on 21/8/2025. That correction has the
Instead
notice
of 22nd,
21, I received it, but the notice is not dated. The date is not there, only the month is there. my lord.
Upharat Korvat আছে 22nd, instead of 22nd mentioned 21/8/21.
And notice dated may not be mentioned. Notice dated is only eight,
Eight.
the month is given, but date is
Date is not given.
blank.
Okay, I'll make necessary corrections.
I'm very grateful, madam. Deeply obliged. to you.
Item 22.
Yeah, no, I'm
Priya Indoria. Indorani Bill. একটু গড়বড় করবে। মন বুঝাও। Yes,
May I please, Lordship? Here in this petition, Lordship, we have challenged the proceeding, Lordship, pending before the learned additional chief judicial magistrate Dorong, Lordship, under section four
item
24.
number
22, my lord.
Yes,
Petitioner name is Salauddin Ahmed. Lord.
yes.
Now, Lordship, kindly see the FIR, Lord, Page
What
15.
you are challenging?
the proceeding of the case, Lord.
Proceeding means what?
Proceeding.
It is pending investigation.
No, Lord.
Charge sheet
Before
has,
that,
PRC trial.
PRC.
what are your grounds?
Lordship, kindly see page 15 part, Lord. FIR.
No, what are your grounds? You tell me.
Lordship, section 420 is not applicable in the instant case, Lordship. So for my eye.
At what stage that proceeding is
In
pending?
copying stage, Lordship.
You take this plea at the stage of framing of charges.
However, Lordship, since the Lordship, it is a matter of totally civil nature and for the sections under which the charge sheet laid, it is not applicable. Lordship, kindly see the FIR first, Lordship, for a moment, Lordship. Page 15, Lordship. May I read, Lordship?
No, at the stage of quashing, after filing of the charge sheet.
Yes.
Can we go into those facts?
First, Lordship, considering the
Your plea is that it is exclusively civil in nature.
in nature and section 420 is not applicable in the instant case, Lordship.
Under what provision cognizance was taken? 468 is also there.
Four land holding certificate.
468 is also there.
Yes. Page 28, Lord. Same sections, Lord, as mentioned in the circuit.
Page 20, para 2.
Forgery and using forged documents.
Kindly, Lord, see the FIR part, so everything will be clear. Lord.
Okay.
Page 15. With reference to the subject cited above, I have the honor to inform you that.
Page number?
Page 15, Lord.
15.
15.
Yes.
With reference to the subject cited above, I have the honor to inform you that one Salauddin Ahmed, that is the petitioner, Lordship, son of Wahidur Rahman of village Satkoria Hindu Kopa Moja under Sivaja Revenue Circle, has posed
Just
a
in Putur. Yes, sorry. Yes.
has posted a landholding certificate where the class of land as per land records, both manual and computerized, is Lahituli, which has been tempered and made Halbur. This is the Lordship allegation. The class of land is tempered. And this affair has been filed by the Lordship Circle Officer, Sivaja Revenue Circle. What happened, Lordship? In the year 2018, Lordship, due to financial constraint, Lordship, on the part of the petitioner, he applied for a loan for a person, Nozmul Hussain. on the same locality and handed over all the relevant documents to get loan lordship. Thereafter, lordship, he put all the signatures on all the papers. Subsequently, the bank authority, when sent for scrutiny those documents before the circular, then it is detected that the class of land is tempered.
What is your case?
In this case, lordship, I have not induced anyone, non-deceived any person's lordship. Our intention is just to get loan. And lordship, ownership is not disputed, lordship.
No, you have, no, the accusation is that you tampered with the,
Actually, lordship, I handed over
Land.
the for getting,
This,
I
please.
entrusted someone, lordship. And I have thoroughly, lordship, communicated the same.
This is not a case. Yes, Mr.
This plea can be raised at the time of framing of charge, and even though matlab, that charge is framed, and then they may come and then the scan copy may be given for let us in the
Only-
if you stay at this stage, matlab.
Classification of land is tempered, lordship.
Something has been tampered.
Yes,
Something has
lordship.
been
I am not
tempered.
denying, lordship. I have entrusted someone, lordship. I have, during
that-
investigation, I pointed out the same to the investigation officers also. Title is not disputed.
There is no accusation regarding title.
Yes, lordship.
Heard Mr. A.T. Sarkar, Learned Counsel. We are calling for this scanned copy of the case diary. Heard Mr. A.T. Sarkar, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Saleh-Uddin Ahmed, praying for quashing of the proceedings of PRC case number 210/2024, pending before the Court of London Additional Chief Judicial Magistrate, Darong Mohammed Staff. Why have you made, okay, issue notice to the respondents? Since learned additional public prosecutor has appeared for the respondent number 1, no formal notice need to be issued to the said respondent. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let also the scanned copy of the PRC case number 210/2024 be called for, along with the scanned copy of Sipajar PS case number 279/218, list accordingly.
Till then, lordship, proceeding may be stayed.
No, you don't have a case, even for admission, but we are issuing notice.
What will happen now? Charge will be framed otherwise. matlab.
Let us see, let the CD come.
May please your lordship, matlab. The petition was arrested. 13/1/2025, and now, my lord, the 237 days in the jail, my lord. The petitioner already he succeeded, my lord. And my lord, earlier, my lord, this honorable court's order, my lord, a scan copy called for, my lord. My ground, my lord, this, there is no reason, my lord, and my lord, there is no ground for, my lord, this a arrest memo in inspection, and my lord, notice, my lord, 47 and 48. Already received the, my lord, scan copy, my lord. Already annexed, my lord, no ground.
Scan copies.
And this, my lord. This honorable courts, my lord, similarly situated
person granted bail, my lord, by this honorable court, my lord, on that ground. I will consider, my lord, on that ground, my lord. I will take that file, my lord.
Where is the notice? Notice under section 47.
In my petition, my lord, page 18 and 19, my lord. And scan copy also, my lord, same. There is no ground of it. My lord, this honorable court passed me the order, my lord.
Page number?
Page number, my lord, 18 and 19. And same in the, my lord, scan copy also call for, my lord. There is no ground of error.
15, 19, 20.
Yes, Mr.
What is there, it is also there, but I want to state one thing, Lordship, I have flag mark also.
Yes.
In the first order sheet, Lordship. Green flag, Lordship, order sheet.
Yes.
There it has stated that he has apprised his family members. And they were to engage an advocate, Lordship, on their own. So the main motto of the section 47 law.
No. Unless you tell him the grounds, in which case, what is the acquisition. He may engage a family member may engage a counsel. But you have a duty to communicate the grounds.
Otherwise, it is not there, law.
What is the contraband? How much is the contraband?
My lord, is my
Mr.
date also.
Z. What is your name?
Date Hussain, my lord.
Z. Hussain, learned counsel for the petitioner. You answer my query. What is the contraband? Quantity of contraband. Z. Hussain, learned. Z. Hussain, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Ikram Hussain Pradhani, who has been detained behind the bars since 13/1/2025 within bracket for last 237 days in connection with
Look, yes.
what is the
Lokipur PS case number.
not PS case number, NDP, what is the NDPS?
Tramadol. Tramadol and another is.
No, what is the, it is pending investigation.
No,
No, my lord.
charge sheet.
So what is the say special case number?
Case number 2.
We'll take it up after some time. You come prepared. What is the special case number? You have not mentioned in the FI, in your bail application. Whether charge sheet has been laid or not.
Charge sheet laid, Lord.
But in order sheets also only PS case is mentioned.
Charge sheet is submitted on 21/5/2025.
31/5/2025. But in the order sheet also, there is no mention about. Where is the charge sheet? In this case,
After filing the case, that is the summary.
so after filing of the charge sheet, what number was given? In connection with Lakshipur PS case number 8/2025, in which charge sheet was laid on which date? When the charge sheet was laid?
Charge sheeted number is Lordship 63/25. 31/5/2025.
No, you verify. I don't think charge sheet has been laid.
Yeah.
No, from the order sheet you verify. We'll take it up after some time. You go through the records. An accused must be knowing the case number. Isatwa. Go through the records of the case. When the charge sheet has been laid and what?
In this case, Lordship, Senior Counsel, Mr. Isara Choudhury will appear. This matter may be taken up at 2 p.m.
Okay.
Is not there. 29.
Her office note indicate service upon the respondent number 2 is awaited till date.
POXO case.
Yes, ma'am. In the meantime, I have filed an affidavit with regard to the events of LCR. With the issue of illegal arrest is also here in this case.
But notice has to go.
Yes, my lord. So let this matter be taken up on 17th of this September.
Heard Mr. A. Paul, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Why have you filed additional affidavit?
Regarding as per order of this honorable court.
What you brought on record?
Some events which has been revealed from the TCR.
Learned counsel for the petitioner has submitted that the petitioner has filed an additional affidavit in pursuant to the directions of this court on 26/8/2025. Stop. It appears from the office note dated 30/8/2025 that the service report in respect of notice issued to has not yet received. Learned additional public prosecutor is requested to take information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date fix. Let this case be listed on 17/9.
My lord, may it please your lordship. My lord, this is a bail plea of the applicant on two grounds. One, that in the arrest of memo nor in the notice of arrest were any of the grounds mentioned. That apart, my lord, it's been 4 years since the applicant has been languishing in jail, my lord, and trial is not progressing, and there is no fault attributable to the applicant, my lord. Such poor is his situation, my lord, that legal aid had to be required for him. Lordship was gracious enough to call for the records to see if there has been some delay attributable to him. Only 3 witnesses have been examined so far in 4 years, my lord.
What is
And
the date? What is the date of your arrest?
My lord, I was arrested on 5th of September 2021. This is indicated in the rejection order also, and I have stated on oath on para 14, my lord.
Where is the rejection order?
Lordship will find it on page 32, my lord, of the bail plea. It's an order of 14th February 2023. May I read it out, my lord?
Yes.
Today was fixed for hearing on petition number so and so for granting bail to the accused named Amren Singh. Heard both sides. Produce petition number so and so in the case record. Case record revealed that the said accused was arrested on 4th September.
You need not to read it out.
My lord.
May I please, your lordship?
Yes.
Your lordship will be filing our objection today. We've just received it this morning, your lordship, and Mr. Kyal will appear in this matter, your lordship. So a short date may be given, your lordship.
My lord, we would have a serious objection to this.
Your lordship, we've received our instructions today and accordingly we'll file it today, your lordship.
May I say something, my lord?
Yes. No,
my
but
lord,
you were given time. Why you are waiting till last date? You know the date was the fixed date.
Yes, your lordship, we've received it just today, your lordship, so we'll be filing.
Mr. Kyal, you are appearing.
We have received today, lordship, we are filing today. Maybe taken up day after tomorrow on Wednesday.
My lord, could I persuade your lordship to consider, my lord, as your lordship has rightly observed that there's been 2 dates, my lord. So it's been almost more than a month since they had time to file objection. Secondly, my lord, so far as period of incarceration is concerned, there is nothing new that they can say. They have the instructions and the case diary with them. They may indicate if there is any fault attributable to me so far as delay is concerned, my lord. They have the case record, entire case diary is with them, my lord. The trial court record is there. They may indicate if there is any fault on account of mine that this delay in the trial has been occasioned, my lord. I have been languishing for 4 years, my lord. I have a son of 6 years and a wife to take care of. There is no earning member, my lord. My family is in dire straits. आप record से बता सकते हैं if there is some delay on my part. Otherwise, having spent 4 years, my lord, I am entitled to bail on this score alone.
Yes.
There is nothing new that you can say in the objections.
This is
You can't travel beyond the records to say that this 4 year is attributable to me. Aap record say you can indicate if there is some delay on my part.
Heard Mr. Shivam Sharma, learned counsel for the petitioner. Also heard Mr. A.C.K. learned standing counsel NCB, who submits that the NCB will be filing its written objection today and prays for listing this matter day after tomorrow.
It may fix on Wednesday.
Though the counsel for the petitioner objected to the said prayer on the ground that the petitioner has been languishing behind the bars for more than 4 years. However, considering the fact that the quantum of considering the quantum of
269 cartoon.
40,102, but also Procedural. Codeine based cough syrup.
Packets of codeine syrup, my lord.
Page number 8, your lordship.
considering the fact that commercial quantity of contraband is involved in this case, and the learned counsel for NCB will be filing the objection today itself, the prayer is allowed. Let this matter be listed on 15th of,
What's it, maybe on 16?
on 16th of September.
I'm beholden, my lord. Deeply obliged. Grateful.
May I please, Your Lordship? All the accused co-accused have been granted bail, and one of the accused co-accused has been granted bail yesterday, Lordship, by Your Lordship. Gaurav Agarwal, Lordship, kindly see the order. Lordship, the facts and circumstances of the cases are exactly similar, Lordship. In fact, they were arrested together. Same time, same, all dates and timings are same, Lordship. I rely on Lordship paragraph 19 to 25 of this order, Lordship, for my submission. All the submissions are same, the dates, the times, everything is same.
The case is also same case.
Exactly same. The case number is same, Lordship.
Yes.
Lordship, case there is with me. Lordship, may please to see whether same offense or offense is same, but incident is not same. He is involved in another case. Lordship, the amount of the tax is different.
Amount is different. This is less amount. That was 29 lakhs, this is 6.9 lakhs.
Lordship, I have some submission. If first my line friend complete their trial.
Okay, you may make your submissions.
Lordship, Lordship, in this case, Lordship, the DGI issued me summons on 19/8/2025, which is which Your Lordship will find at page 25. Lordship, page 25 is my summons. Firstly, Lordship, the search and seizure took place in my premises, and then a summons was issued to me on 19th of August 2025. Lordship will find that the page 25, annexure 2, now therefore in excise by the bold one, Lordship, by an authorized representative 19/8/2025 at 2:30 p.m. Accordingly, Lordship, I had appeared. So I had fully cooperated with the investigation agency, and thereafter, Lordship, they have arrested me on 28/2025. Lordship, while arresting me, Lordship, the provisions of section 35(3) has not been followed, because my Lordship, the maximum period for which my this will be 5 years, which is less than 7 years. So 35(3) has not been followed. In the absence of section 35(3), Lordship, 35(1)(b), it should have been followed. That has also not been followed. Lordship, may kindly see the reason of belief, which is given at page 28.
Page
28, Lordship.
Yes.
Lordship, last paragraph may kindly see. He has not divulged all the details and certain so and so. Thus, his custodial interrogation, which is elicited oriental, is absolutely necessary in this case. There is a need to cover other associated person, with brokers and reception involved in GST evasion. At the stage of investigation, there is possibility that he may influence witness, temper the evidence, and scuttle the ongoing investigation. Additionally, his presence is required for timely completion of investigation. Thus, I am considered opinion that so and so is to be arrested to ensure fair investigation. He was arrested by the same investigation officer who has arrested Mr. Gaurav Agarwal. So the same Lordship facts has been mentioned. And it is not that they have not stated that I will be absconding, which was the primary condition in the Lordship instruction in their own instruction by the CBIC, which says that the guideline for arrest, Lordship, page 34, the guidelines which is there for arrest and bail.
Yes.
Lordship, you will see the judgment in which, Lordship, 5 lines from the above, a distinction, Lordship. A distinction must be made between the existence of power to arrest and justification for exercise of it. If arrest is made routine, it can cause incalculable harm to reputation and self-esteem of a person. If the investigation officer has no reason to believe that the accused will abscond or disobey summons and has in fact thoroughly cooperated with the investigation, we fail to appreciate why there should be a compulsion on the officer to arrest the accused. So, Lordship, I had it is on record that I have cooperated with the investigation, and therefore, Lordship, I should ought not, it is beyond their own instruction. Secondly, Lordship, the section 35(3) has not been followed because it is a case where it was less than 7 years. 5 years is the maximum sentence that can be Lordship leveled against me. Judgment and Lordship.
What is the accusation
alleged
against? What is the accusation against you? Same, you
Lordship, same
issuing fake invoices.
The amount is, Lordship, amount in respect of Lordship Gaurav Agarwal's 29.93 crores. Oh, in my case is 6.9 crores. That is the only difference, Lordship. My amount is less than Mr. Gaurav Agarwal's case. And Lordship, they have filed a bail objection against me. Objection against affidavit which has been filed. If your Lordship will see, Lordship is there on record.
It is there.
Lordship, I am relying on his affidavit, Lordship. It is completely in my favor. They have said that there are materials against me, but Lordship, they have stated in their affidavit that my co-accused has been released on bail. They want to file appeal before the Guwahati High Court. Another co-accused, Lordship. One co-accused is Mr. Gaurav Agarwal. Another was Mr. Shiv Mittal, who have already been released on bail because he had, Lordship, the technical errors. Again, the same technical errors. Lordship will see that he has been accused and they want him behind the bar. My petitioner behind the bar. Lordship, may kindly see paragraph 7 of the bail objection that they have filed. I strongly rely on his bail objection.
Yes.
Lordship, may kindly see paragraph 7, last 3-4 lines. Additionally, Lordship, the entire paragraph says that the co-accused Sri Shiv Mittal, partner of Messrs. GM Cox, and his relevant submissions were recorded during the custodial statement. Finally, it is written. Additionally, it is also submitted that the bail of Sri Shiv Mittal was granted on a technical ground by stating that there is no formal written complaint against the accused, no case diary has been produced, no checklist has been provided, and appeal against bail order is being filed before the Honorable Guwahati High Court. So they themselves are saying that this is the co-accused in connivance with and he has been already granted a bail by the magistrate, and they are filing a high court petition before the High Court.
How this co-accused is relevant?
Lordship, because they have named him.
Where?
They have named him not in the FIR, Lordship, but they have named him in the bail objection only. In this paragraph only, they say the petitioner was confronted with submission made by other co-accused. This is Shiv Mittal. They themselves are admitting that this is my co-accused. This is also, Lordship, in relation to the same case number.
No, I'm not getting it. How Shiv Mittal is connected?
Lordship, they are saying
Shiv Mittal named you.
Shiv Mittal, they are interrogating both of us together.
No. Oh. Suppose Shiv Mittal is granted bail. So, what is your submission?
I just wanted to bring this to a notice of your Lordship that all co-accused have been granted bail because of technical whatever they have done. That is my only to bring to the notice of this court.
Okay.
Lordship, thereafter, Lordship, may kindly see that page 50. Lordship, may kindly see point 3.6. 3.6. They say that the custodial statement of Sri Deepak Garg was recorded in continuity. Earlier, I appeared on 19th and the statement were taken till 20th. Then
you are Deepak Garg.
I am Deepak Garg, Lordship.
Okay.
On 21/8, 22/8, 23/8, 25/8. And I'm being.
This is after your arrest or before your arrest?
This is after my arrest. 19th and 20 were before my arrest.
Okay.
These were after my arrest. Again, Lordship, they had taken some permission from the judicial magistrate. Again, they interrogated me on 2nd of September, which is at page 17. They have themselves annexed. Page 17, paragraph 17, page 58, they have annexed that on 2nd of September also they have, Lordship, investigated me.
Okay.
On Lordship, they say that I may not be allowed to go on bail because I may again issue fake invoices, which they write in paragraph 10 that the reason for which I should not be allowed to go on bail is that I may again issue fake invoices, so I should not be allowed to go on bail. Otherwise, the investigation is almost over. And Lordship, they have not followed any of the rules. Lordship, section 35(3), which was the mandatory precondition that they should have followed before, Lordship, has not been followed by them.
Anything else?
Lordship, I'm relying on Gaurav Agarwal because exactly the same case. He's the brother of Mr. Gaurav Agarwal, and they were both arrested together in same facts and circumstances of the case.
Present petitioner is the brother.
Mr. Gaurav Agarwal. Both were both of Lordship, the same in search and seizure were done on the same day, and Lordship, both were arrested together.
Okay.
So Lordship, the both circumstances are same, and since one of this accused has been granted bail, this I pray that.
Where is the authorization for arrest in your case?
Authorization of arrest you will find page 28. That is reason to believe, Lordship. Last paragraph I have read. There is need to cover other associated persons. At this stage of it, there is
No,
possibility
you read it completely. Let us read it.
Investigation has revealed that Sri Deepak Agarwal, age 43 years, son of late Suresh Garg, so and so, is operating 4 dummy entities. Faithful Trade Venture, so and so. These entities are registered in the names of unknown unrelated persons. Evidence, including his statement and relevant GSTR returns, has revealed that during this period from December 22 to July 25, he has issued fake invoices of coke. Fake invoices of coke without supply of goods. By using these 4 dummy business entities, thereby passed on ineligible ITC of 6.93 crores. Within bracket, the amount is mentioned to its recipients. These fake invoices have led to wrongful embezzlement and utilization of ITC amounting to rupees 6.93 crore by its recipients. Thereby, he has committed an offence under section 132(1)(b) of the CGST Act, which is punishable under section 131(1)(1) of the CGST Act.
132(1)(b).
Yes, Your Lordship, B. That was
But
1A.
your brother was 1A. Okay.
Which is punishable under section 131(1)(1) of the CGST Act, and it is cognizable and non-bailable under section 132(5) of the CGST Act. Investigation is still at nascent stage. He has not divulged all the details and certain crucial facts, information relating to GST evasion. Thus, his custodial interrogation, which is elicitation oriented, is absolutely necessary in this case. There is a need to cover other associated persons, which brokers and recipients involved in the GST evasion. At this stage of investigation, there is a possibility that he may influence, witness, tamper the evidence, and scuttle the ongoing investigation. Additionally, his physical presence is also required for timely completion of investigation. Thus, I am of the considered opinion that Sri Deepak Garg at the rate Deepak Agarwal is to be arrested to ensure fair investigation. Therefore, I exercise authority granted under section 69 of the CGST and authorize so and so senior intelligence officer to arrest Sri Deepak Agarwal at the rate Deepak Garg. This is the reason to believe, Lordship, they have given authorization to arrest.
Okay. Yes, Mr. Ken.
First, my submission.
GST
In case of bail, there is no question of parity. In this respect, Lordship, I want to place few judgments. Lordship, one judgment passed by this honorable court for paragraph 15 and 16. The gist of the judgment says that each and every case is its own facts and circumstances which is to be taken into consideration for deciding there. In this case,
Yes.
this may Lordship paragraph 15 and 16. Then another judgment, Lordship. This is passed by Honorable Supreme Court, reported in 2024 legal SC page 1135, paragraph 6.
What it says?
It says that Lordship, paragraph 6, I'm reading. This is a small judgment. The judgment which review is sought to be considered the role ascribed to the petitioner indulging version of the charge sheet to ally the petitioner's apprehension. Authorities concerned have to directed to render appropriate care and assistance apropos to his medical condition. The claiming caveat that a bail application preferred phrased by the petitioner shall be considered on its own merit without prejudice to the cancellation of the bail order and also find place of the judgment dated so and so. We do not appreciate the casual aberrations to the effect that once the bail granted by the Honorable High Court is cancelled by the High Court, neither the learned trial court nor the High Court would grant bail to the review petitioner. The High Court also as a later period or in the event of change circumstances, the discretion of the court leave to be exercised in accordance with the courts below is left untouched. Nevertheless, the petitioner chooses to apply while considering such bail plea. Court concerned need not fail inhibited by the observation, if any, against the petitioner in the judgment dated so and so. The above being the position, the review application dismissed. So, Lordship, this was the observation of the Honorable Supreme Court. And Lordship, another judgment.
No, what? I could not understand what it.
Lordship, the judgment
means.
says that parity cannot be a ground for granting bail.
No, for that you have already cited another judgment.
Yes, Lordship, this is another judgment, Lordship, paragraph.
No, you need not to submit on one case if.
This is more clear, Lordship, this judgment.
Okay. Then don't give judgments which are not clear.
No, Lordship, in this case, what happened, Lordship, the bail was granted, then he filed a review petition, bail was cancelled, then he filed a review petition that I was granted in bail in another case. So, koi case and granted bail. Supreme Court says that no, parity cannot be a ground for granting bail in your case. In this case, Lordship, Ashish Yadav versus Yaspal and others, paragraph 11.
So your basic submission is that case of present petitioner is different from Gaurav
Yes.
Agarwal's case.
Yes, sir. So
And it should be
consider
considered on the merit of the facts of the.
Lordship. Now,
Okay.
Lordship, regarding Lordship 69, because Lordship, this is a special act. Section 69 was upheld, 69 and 70 was upheld by the Honorable Supreme Court in the case of Radhika Agarwal and others. Now, last occasion I submitted before Lordship.
Yes.
And this is a parameter with Lordship, one submission is made that we have not followed the section 35. Lordship, please to see section 35. Section 35 with parameter of section 41 of earlier CRPC.
Yes.
Section 35. Police, when police may arrest without warrant. A police officer may without an order from the magistrate and without a warrant arrest any person A who commits in presence of the police officer or cognizable offense or against whom reasonable complaint. Section B will be applicable in this case. Against whom a reasonable complaint has been made or credible information has been received. So let's say credible information is received, section 69 Lordship, now Lordship may take up section 69 of GST Act. And this section was challenged before Honorable Supreme Court. Supreme Court in Radhika Agarwal case upheld this section, section 69. Power to arrest.
Yes.
Where a commissioner has reason to believe that a person has committed an offence specified in clause A or clause B or clause C or clause D of section 1 of section 132, which is punishable under clause 1 to 2 of subsection 1 of subsection 2 of the said section, he may by order authorize the officer of the current tax to arrest such person. Let's say saying 35B and this provision. And this provision was upheld by the Honorable Supreme Court in Radhika Agarwal's case.
No, what is your submission?
My submission is that
69 operates in a different field.
no. Lordship,
Let me tell
Yes,
you what I understand
Lordship,
so that you can make me understand properly.
Lordship.
69 says that if there are reasons to believe
Yes.
that what? That there are materials,
Yes, against him.
there are materials to suggest that the person who is required to be arrested has committed offense under section 132A to 132D.
Yes.
So 69 says that whether there are materials or not that he has committed an offense under.
Certification of the commissioner used to be recorded.
Yes. And 35 operates on a different field. 35 says that if the offense is punishable for less than 7 years, and then if you need to arrest that person, then it must be based on clauses A, B, C, D, E of 35 1B2.
Yes, sir.
Unless one of those A to E circumstances present and you justify it giving reasons, that one of the reasons is that I'm giving an example, that he may tamper with the evidence.
Yes.
This is a condition which must exist, but you have to give out reason why you are arriving at the conclusion that he may tamper with the evidence.
Okay.
Mere mechanical reproduction,
It will not.
that will not do.
Yes, correct.
So 35 and 69 operates, though they look similar.
Lordship,
This is my understanding. Now, what is your submission?
Lordship, this is a special act. And section 69 and 70 were put under challenge before Supreme Court. That was decided in Radhika Agarwal's case. And Lordship 35B, again, I'm reading for my satisfaction, Lordship, against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense punishable with imprisonment, this term may be less than 7 years. This speaks about the Lordship provision of IPC or Nagrik Sanhita Act. And we are dealing with a special act. Lordship. Here, section.
No, it does not speak about IPC.
No, Lordship, because it is a provision. Lordship, again, I'm reading section B, 35B.
Yes.
Against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense punishable with imprisonment of a term which may be less than 7 years. Here punishment is 5 years. Maximum punishment 5 years. It depends upon the amount. If the amount is above 5 crores, then offense is non-cognizable and non-bailable. And below that, Lordship, it is cognizable and bailable. Non-cognizable and bailable. So here, Lordship, all reasonable suspicion. What section 69 says that.
No, that is okay. That is there. Reasonable suspicion is there regarding commission of, that he is involved in commission of the alleged offense. That is there. But requirement of arresting him To
That-
justify that, you have to follow 35(1)(b) within bracket 2, Roman 2,
police officer is satisfied. Lordship, the here,
where the police officer is satisfied.
they are not the police officer. Lord. They're given power under special act, under section 132 and 69 and 70 law. This has been clarified by the Honorable Supreme Court in Radhika Agarwal's case.
So your submission is 35 is not applicable.
Lordship, even if it is applicable, then 69 is there. So all provision has been complied with because it is parameter is the provision of section 35 incorporated in section 69. And this provision was challenged before the Supreme Court preliminarily on this ground. That was negated by Supreme Court. On last occasion I submitted, Lordship, I have again submit this judgment. Because it is clear that section 69, 70 is upheld by the Honorable Supreme Court. And Supreme Court has said that if there is any minor discrepancy, that cannot be taken into consideration in special act while dealing with the case. While in judicial review also, paragraph 12 of the judgment laws. And Lordship, this aspect
No.
of the matter was dealt by
Okay.
our High Court.
Is it your submission that because in view of section 69 of GST Act,
Lordship.
section 35(1)(b) clause 2 is not applicable?
This is my submission.
That is your submission?
Yes, sir.
Okay.
Because the officer of the DGI are not police officer as held by the Honorable Supreme Court.
Okay.
And Lordship, this point has been already been clarified by our High Court in one of the judgment reported in 2021 4 GLP page 470. This was with respect to Assam goods and service tax, and this is under central GST. Same provision is there, section 69 172, paragraph 31, 32, 33, 34. Married law.
Yes.
Paragraph 31. In view of the submission of the respective learned counsel for both the parties, as exhaustively indicated above, this court is of the view that section 132 in the section section 69 of the AGST Act provides, all these sections are similar. Provisions are there in CGST Act and AGST Act. Providing the power of arrest is only with the regard to the nature of the offense specified in clause A, B, C, and D of subsection 1 of section 132, for which the punishment is provided in the clause 1 and clause 2 of the subsection 1 of subsection 2 of section 132 CGST Act. Therefore, when a commissioner form an opinion and has reason to believe that a person has committed an offense as specified in clause A, B, C, and D of subsection 1 of the aforesaid which is punishable under section 1 and 2 of the subsection 1 of subsection 2 of section 132 of GST. He may be order authorize any officer of the central tax to arrest such person, and accordingly and on authorization to arrest the accused persons on the strength of the said warrant. The accused was arrested on 12/7/2021. This court is of the view that arresting authority falls under the term of proper officer. This court is of the further view that in disagreement with the submission of the learned senior counsel for the petitioner, that the respondent authorities cannot invoke the power of arrest under section 69 dealt with section 132 of GST Act 2017 prior to the completion of adjudication assessment is bereft of the reasonable and valid logic. Section 69 is independent of section 132 of the GST Act, which falls under chapter 19, which prescribes the offense and penalties. The plain perusal of section 132 of the Act indicates that it is the only provides punishment for certain
No,
offenses.
no. This justifies 69, power under 69.
Yes, Lordship. This is
I am
my-
not in doubt over that. My query is what you have submitted, that in view of section 69, whether provisions of 35 would be applicable or not.
My submission, it is.
It is not applicable.
Yes.
But the judgment does not say that
No, Lordship,
about 35.
this does not say about 35.
That was my query. You
No.
justify that because of 69, 35 is not applicable.
And I'll address tomorrow
No.
on Wednesday, Lordship.
No,
Because Lordship has made a query, whether it is applicable.
Ah,
or not.
yes, this is important.
It is important, Lordship, to
Lordship,
decide.
there is a judgment of Bombay High Court on exactly on this point. I'll place before your lordship. That is on for 41A. Before coming to exactly on this point, the court said that it
We'll
has you have to follow
continue.
it.
Thereafter, Lordship, Supreme Court has decided all these issues. I'll place all the judgment, and this is supported by.
We'll continue at 2. Then we'll decide whether to grant you time or not.
Because the Lordship has made query, so it is my duty
No,
to
you-
address on this. point.
Yes, if it is not answered,
That's why I have taken permission from both sides. And I can do that matter.
we'll take it up after 5 minutes. Let me.
Yeah.
We are in the midst of a hearing.
Yes. You may take time, my lord.
Huh? We'll take it up after this. 43, item number 43 is there. Okay. Yes, Mr. KL. The query is in view, you have, is it your submission that in view of provision 69 of the okay. So your submission is that requirement of 35 has been complied with by the authorization letter of in the authorization reasons have been given. Okay. Yes. No, what is the basis of this possibility? No, that is okay. But the author, he is stating that his section 35 B2 last line. Because this, no. No, last, after E. Okay, Anish Kumar clarifies it. In Anish Kumar's case, what is required to be written? this you have submitted in Jagan Mohan Reddy hai. No, okay, this I agree. Whether it allows the investigating officer to violate 35. And your submission is that you have followed. Okay. Yes. No, this is not applicable. And otherwise, he has complied with the summons. Yes. So what is your submission? In this case, is there any procedural lapse or whether there is no procedural lapse, or if it is there, it is minor procedural lapse? What is your submission? So there is no procedural lapse. No, I want your submission. Okay. That can be treated as minor procedural lapse. Their main plea is 35. Okay, that I will examine. No, suppose, assuming that this court comes to a finding that 35 has not been followed. No, I want to know your submission. Then can it be treated as, in the context of this case, that this lapse is a minor lapse? Okay.
So, section 55, some conditions are there. For offense letter, we have complied with all these conditions.
Okay.
Section 69 has been upheld by the Supreme Court in April.
No, this 69 is not challenged, neither by them.
So that's all the provisions of section 35 reported in section 39. Well, is the authorization.
Okay.
Official notice before all of this, they have complied with first, if they have complied with all the provisions. If there is minor difference is found by a lordship, that may be compounded.
No, one last query. That is it your submission that section 69 is in pari materia with section 35? Okay. Heard. Okay. On Monday. Heard Miss N. Havelia, learned counsel for the PT. You give me the case diary. Also heard Mr. S.C.K.L., learned additional public prosecutor. Let this matter be fixed for delivery of orders on 8th. Oh, sorry. Learned Standing Council DGJ. 8th of September.
They have cooperated and whatever all I'm relying 43, 44, 44 only.
Okay.
43, 44, the Lordship has extensively dealt with. And Lordship, that Radhika Agarwal says that if there is any stringent safeguard provided under the statute, that has to be followed. It's been laid down in by. And the person who has been released on bail has been cooperating with the department. Yesterday also he has appeared before the department. Yesterday he appeared before the.
No, that case is not before me.
Yesterday.
His wife submitted application that my husband will on 25th and then she also he submitted
No, that matter is not before me now. Okay. Wait till Monday. Okay.
I'll be relying on Gaurav Agarwal. Much obliged.
Yes. Item number 43, Mataksi. Yes, Mr. Sharma, you can.
My lord, your lordship is already dealt with this case, my lord, the CID case of 04 of 2025. And in 16 persons have been granted NC bail, my lord. I've got the order passed by your lordships. He is a driver, my lord. And his name was inducted in the, although not named in the FIR, my lord, but police was searching him.
His anticipated bail was rejected earlier.
Is it?
No.
No.
Amit Kumar, no.
Okay.
The first one. Case diary was called, case diary is here. And your lordship, what is your 16%, except one, Sumit Das was found to be main culprit. He was refused bail, others were given. He is simply a driver, man. Read up to class 8 only.
Yes.
The fee persons were allowed BA also, not all AB. Already I submitted in this case, two groups, Abu Hanif Chaudhary and all this, and this group is Ranjan Pegu, along with he 62 Amit Talukdar, Ranjan Pegu, and then Shankar Kumar Bhumik. Associated with Shankar Kumar Bhumik. Shankar Kumar Bhumik made the provided those appointment letter, fake appointment letter to the Ranjan Pegu through WhatsApp. And this person, Amit Talukdar, also collected some amount of money and given to Shankar Kumar Bhumik. So, material such that he one group is Abu Hanif Chaudhary, Zakaria Ahmed. Those cases were granted after almost statutory period is yet to be completed.
Main culprit was more Sumit Das.
But what is your case?
No, main culprit Sumit Das also involved. But two group, one is Ranjan Pegu main, one is Zakaria Ahmed, Zakaria, Abu Hanif Chaudhary and all this. Along with this Ranjan Pegu, Shankar Kumar Bhumik and all this Sumit Das, yes, he also there. He also there. And Amit Kumar Talukdar, he.
Then why are you apprehending your arrest?
Hello?
Why are you apprehending arrest?
I have said, my lord, the police is searching me also.
Whether notice under 35(3) has.
No. No.
You are searching for him.
Yes, my lord. I was given detailed report regarding he has collected money and given to Shankar Kumar Bhumik and then with Ranjan Pegu group. That group. Starting from.
No, but the offense is punishable under for less than 7 years. If he cooperates in the investigation, then whether custodial interrogation would be necessary. What is his role? He collected money.
He collected money from different. He is not the key person. That is clear. He is not the key person. But
man is Shankar Bhumik.
Collected money from some persons and given to Shankar Bhumik.
Heard Mr. R.P. Sharma, learned senior counsel, assisted by Ms. B. Das, learned counsel for the petitioner. This application under section 482 of BNSS has been filed by the petitioner Amit Talukdar, who is apprehending his arrest in connection with CID case number 4/2025 under section 61 within bracket 2/318 within bracket 4/336 within bracket 3/340 within bracket 2 of BNS. The gist of accusation, quote, para 3 from AB case number 1576. Learned counsel for the petitioner has submitted that the petitioner has not been named in the FIR, and in the meanwhile, many accused persons have been granted either anticipatory bail or regular bail by various courts. He submits that the petitioner, who is a driver, what petitioner does,
Driver man, driving private car,
driver of,
private car, private engagement.
he is a driver by profession. However, he has been, and police is calling you telephonically, or
They went to, they visited my house after searching me.
the police is searching for him in connection with this case. He submits that the offenses involved in this case entails maximum punishment of up to 7 years only, and therefore it requires issuance of notice under section 35 within bracket 3 of BNSS. However, the petitioner has not received any such notice, but the threat of getting arrest is there. Stop. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation, and therefore he submits that he may be allowed to go on anticipatory bail. On the other hand, learned additional public prosecutor has produced the case diary of
CIDPS case number
CIDPS case number
4/2.
4/2025. He submits that in this case, the two groups of persons led by, one group led by Ranjan Pegu, another group led by
Abu Hanif Chaudhary and Zakaria Ahmed.
Abu Hanif Chaudhary and Zakaria Ahmed took money from various persons on the pretext of giving them appointment as master role / work charge employee in Water Resource Department. He submits that there are materials against the petitioner in the case diary, though he fairly submits that the petitioner is not the main culprit in this case. I have considered the submission made by learned counsel for both sides and have gone through the case diary of CIDPS case number 4/2023. It appears that no notice under section 35 within bracket 3 of BNSS has been issued to the petitioner, though the police is searching for him. It also appears that the petitioner is not the main accused in the case, and considering the progress made in the investigation, this court is of considered opinion that if he cooperates in the investigation, his custodial interrogation may not be necessary. Quote paragraph number 14, instead of they, he likhibo. You appear before the IO within 7 days, 30,000 with one security of like.
10 days. So
Why
tomorrow,
10?
tomorrow is after certificate copy, I'll get on Monday only.
10 days. Okay, 10 days. This bail application is accordingly disposed. Next item 43. 43,
Malo, 30,000 malo.
30,000 with one security. What?
This Duluram Gogoi, my lord. Duluram Gogoi has collected money and given to directly to the Anand Baby. from few job seekers, my lord. In that case, other case, he given to Shankar Kumar Bhumik and then Ranjan Bhaigu. He has given money to Ranjan Bhaigu.
There are materials, incriminating materials.
But
against
my lord, I am not named in the FIR.
FIR
FIR, it only relates to circulation of a fake letter.
Yes.
Why you are
investigation,
apprehending your arrest?
Because my lord, police visited my residence and no notice was served upon me. I am ready to cooperate, imposing any condition. my
Same
lord.
order. Same order appear 47 in, that is 62 and 47, same order. 62 and 43.
Within 10 days,
Within 10 days, you appear.
30,000.
30,000.
Obvious, my lord.
My lord, only that he is with the Ranjan Bhaigu group. He given money to Ranjan Bhaigu money. Yeah. That is not reflected in the material.
That is not.
Item 26 and 27. The lordship, my lord, the initial stage, the accused person arrested and the CD was called for. Thereafter, my lord, this learned PP, my lord, the
Whether charge sheet has been filed or
charge sheet has been filed, my lord.
whether
I am in item number 27, my lord, may I interfere? As your lordship directed, we have gone through the, my lord, case record, my lord. Only we have found there, my lord, the charge sheet date and charge sheet number. But so far,
there is no order
there is no
receiving
order
the charge
and, my
sheet.
lord, perhaps a special case is yet to be numbered, my lord. That has not been numbered. So level is. I have not found lordship in the case number. So it is at charge sheet stage, my lord. Charge sheet has been submitted. And numbering, my lord, yet to be done.
No, charge sheet has been, if charge sheet is submitted before the special judge, he would reflect that in the order sheet. But there is no such order.
But I have received this one instruction.
Okay. Heard, Mr.
In item
Otherwise,
26,
not updated status report may be called.
otherwise, it will take again, we have waited for long time. Well, my observation may be given. Only allow my.
Otherwise, 47, 48 has not been
Yes.
completed. Heard, Mr.
Yeah.
Z.
26.
J. I. Hussain. Z. Hussain.
Yeah, 26.
Z. Hussain. Also heard Mr. K. K. Parashar, London. K. K. Das, London. Additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Ikramul Hussain Pradhani, who has been detained behind the bars since 13/1/2025, within bracket, for last, how many days? 230. 237 days in connection with Lakhipur PS case number 8/2025 under section 22C/29 of the NDPS Act. The gist of accusation in this case is that where is the FIR?
FIR page, my lord. Page 12, my lord.
That on 12/1/2023, one Dao Singh Taifa, DAWACNG, TAIAFA, Taifa, comma, SI of police had lodged an FIR before the officer in charge of Lakhipur police station, comma, inter alia, comma, alleging that on receipt of an information through reliable sources that two persons will be carrying some narcotic drugs in a carton and would be selling the same at Jaleshwar, Kadamtola, Brahmaputra River Ghat, comma, a team of police was constituted and it reached the spot. Stop. at the place of occurrence, the two accused persons, including the present petitioner, were apprehended, and from their possession, one carton box was recovered, which contained 90 strips of Sempex plus tablets containing tramadol, 100 bottles of Shivkov TS syrup containing codeine phosphate. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since for last 237 days, and he is seeking bail in this case mainly on the ground of violation of his constitutional, mainly on grounds of violation of his fundamental rights under Article 22(1) of the Constitution of India, inasmuch as though the notice under Section 47 was served on the petitioner, however, it did not contain any grounds of arrest or the basic facts which necessitated the arrest of the petitioner in this case, in the above said case. Learned counsel for the petitioner has cited a ruling of the apex court in the case of Vihan Kumar versus State of Haryana and others, reported in 2025 5 SCC 799. He submits that the violation of the mandate of the Constitution under Article 22(1) of the Constitution of India, as well as under Section 40A(7) of the BNSS, has rendered the arrest illegal in view of the aforesaid judgment. Stop. And therefore, he submits that the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor has submitted that in the aforesaid case, charge sheet has been, what is the date of charge sheet? Charge sheet has been laid
5/2025.
bearing charge sheet number
63 of
63 of
25.
25, dated 31/5/2024, and has submitted that there are sufficient materials against the petitioner in the record. He also submits that the quantity of contraband seized in this case is commercial quantity, and therefore embargo of Section 37 is applicable to this case. However, he fairly submits that in notice served on the petitioner under Section 47 of the BNS, nothing apart from the police station case number and the penal provision contained involved in the act has been mentioned, involved in the case has been stated therein. I have considered the submissions made by learned counsel for both sides and have gone through the records of this case. Gone through the scanned copy of the records of the Lakshipur PS case number 8/2025. Stop. Though learned counsel for the learned additional public prosecutor has submitted that charge sheet has been laid. However, no order to that effect has been found in the scanned copy of the record. Stop. It appears that in this case, notice under Section 47 of BNSS which was served on the petitioner on 14/1/2025, that is immediately after his arrest, it contains only police station case number, that is Lakhimpur PS case number 8/2025, as well as penal provisions involved in the case, that is under section 22C/29 of the NDPS Act. No basic facts which necessitated the arrest of the petitioner in this case has been stated in the said notice. Therefore, there is apparent violation of the fundamental rights of the petitioner guaranteed to him under Article 22(1) of the Constitution of India, as well as statutory rights under Section 47 of the BNSS. And in view of the observation made by the Apex Court in the case of Vihan Kumar versus State of Haryana and another Supra, such violation would render the arrest itself illegal. And on that ground, the petitioner is entitled to get paid. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned Special Judge Gwalpara with following conditions, trial conditions. Same order in item number 27. Only name of the petitioner will be different. And name of the council, AFNU Molna.
Deeply obliged. Deeply obliged.
28.
Yeah.
Can you pass over the medal for time?
Charge sheet submitted.
That sheet submitted,
Civil Council HOS order is on legs.
but charge sheet has been submitted. What is the case? You are appearing for POXO is there.
Yes.
Which item?
28.
What is your name?
Lordship, Mr. Esarasudri is coming, Lord, for the time, short accommodation, Lord. He's on legs, Lord.
No, charge sheet has been submitted.
Yes, Lord, scan copy was called for us.
Oh, scan copy already called for on last day. Yes, that is not received. Okay.
But
I was on that.
this is a POXO matter.
Right.
After filing of the charge sheet, you have to appear before the trial court.
Since the court is called for, Lord, after perusing the scan copy order may be passed, Lord.
No, I'm inclined to pass the orders without perusing the record. Because charge sheet has been, you think, okay,
After some time.
after, we'll take it up after some time, let him come.
The 483 application, my lord. Allegation against me, my lord, 3083 of BNF and 10 and 13 of UAPA. I am in custody for last 38 days, my lord. That is stone arrest, my lord. Page 14 is FIR.
Yes. What is your name?
My name is Sofiuddin Ahmed.
What?
Sofiuddin Ahmed.
Safiuddin Ahmed.
Yes.
Okay.
In FIR, my lord, there is no name accused. Sir, I would like to inform you that on 28/5/2025 at about 1:35 PM, I received a message from some unknown number, being number so and so, stating Major Aidyaman Ahom, G2 Evasion, Sanjukta Mukti Fauj Ahom, Sanjukta Mukti Bahini Ahom Sadin Kotha Pati Lok. And thereafter, on the same day at about 1:46 PM, I received a voice call from the same unknown number. And after receiving the same, the other side online state my name and the name of my family member. That the unknown person told me that he knew everything in detail about my family and said that your son is running business of medicine wholesale and previously he was a lecturer at Moran College and your daughter is a lawyer in Dibrugarh and recently you solemnized a grand wedding on your son, etc., etc., and threatened me and demanding money. Thereafter, I came to Moran police station to inform the matter and I blocked the.
Threat was given,
Yes, my
threatening was given.
yes, my lord. And
Thereafter,
yes, thereafter, my lord, forwarding report, my lord, kindly press 17, my lord. The police stated here that I have other cases, my lord, that is 424, 86, 471. That was substituted. And my lord, page 18, my lord, that is my lord, relevant person. Page 18, para 4, my lord. Serial number 4, my lord.
yes,
The victims of the case number 58, 2025, Tamizuddin has been an opposite party of the arrested accused Sofiuddin Ahmed for a long time for land dispute. On the other hand, the arrested person of Moran PS so-and-so number owes many lakhs of rupees to the victim, Horen Borgohai, for some old transaction. This facts clearly implies that the accused arrested person of Moran PS so-and-so Sofiuddin Ahmed has been providing information about the victims of the instant case and also other victims of the other cases of his personal gain and harm to the other victims. There is a dispute between land dispute and police has arrested in my lord only suspected my lord that he may be informed my lord, that the accused. Demand was made by the Ajjaman Assam my lord. Then my lord, even my lord, annexure 3, I have annexed my nephew, my lord, Asfiq Hussain, annexure 3, page 19, my lord. My nephew has also filed an FIR, my lord, that is to the DMU for demanding money by the Alpha, my lord. He is my nephew, my lord. I have annexed, my lord.
yes, what is,
Lordship, he has assisted, Lordship, assisted the band organization Alpha
how,
Major, yes,
how he has this?
by providing information about the property of victim, victim, Lordship.
Anything else?
Lordship, he is assisted, Lordship, that means.
Okay, heard Mr. M. Tolita, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Safi Uddin Ahmed, who has been detained behind the bars since which date?
Since my
Since
lord,
28/7/2025,
28/7
within bracket, for last 38 days in connection with Moran PS case number 58/2025 under section 308 within bracket 3 BNS, read with section 10/13 of Unlawful Activities Prevention Act 1967. The gist of accusation in this case is that on 4/6/2025, one Tomizuddin Ahmed had lodged an FIR before the officer in charge of Moran police station, inter alia, alleging that he received some messages from an unknown number, that is 9366863016, where threat has been given to him by in the name of United Liberation Front of Assam, within bracket, independent. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR. He submits that he has long-standing dispute with the informant of this case, namely Mohammed Tamizuddin, and only due to the said fact, he has been arrested in connection with this case. Learned counsel for the petitioner submits that the petitioner has been arrested merely on suspicion, and he has already been detained behind the bars for last 38 days. He submits that considering the period of detention, he may be granted bail in this case, as the petitioner is ready to cooperate in the investigation. On the other hand, Ms. Endas, the additional public prosecutor, has produced the case diary of Moran PS case number 58/2025 and has submitted that there are sufficient materials in the case diary indicating that the present petitioner has assisted the proscribed organization Alpha within bracket I in providing the details about the victim to the said organization. So I have considered the submissions made by the counsel for both sides, and have gone through the case diary. So though there are materials against the petitioner in the case diary, however, considering the nature of accusation against him and also the fact that the informant is having dispute with the petitioner, which is admitted even by the investigating officer in his forwarding report. Stop. Forwarding report, comma. Also considering the period of detention undergone by the petitioner within bracket 38 days. This court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of the investigation of the above noted case. Hence, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Dibrugarh, with following conditions, number 1 and number 2. Send back the case diary. This bail application is accordingly.
May I please? Lordship, this is a case of completed case, Lordship. Petitioner is facing trial as a UTP law.
Since when you are behind the bar?
Lordship, initially I was arrested in year 2021, Lordship. And subsequently I have been released on bail, Lordship. And in the meantime, Lordship, I have missed few dates. So NBW was issued, Lordship. And I have been arrested and produced before the learned court below in execution of that warrant of
When?
arrest, Lordship. That is on Lordship 6/11/2023, Lordship. I have annexed that order, Lordship, wherein I have been
Since 6/11 you are behind the bars.
Lordship. On page number 39, Lordship, the order I have annexed when I was produced, Lordship. 6/11, Lord, 2023, Lordship. Page 39, Lordship.
Then have you prayed for bail before the
Yes,
trial
yes,
court.
I have appealed before lordship.
Where is the rejection?
That bail has been rejected, lordship. That bail rejected on the ground that I have missed the dates, lordship, and secondly,
Where is that order?
lordship. That pays lordship that an order, 40 lordship, 40.
Whether victim has been examined?
Lordship, since arrest lordship on 6/11/2023, lordship, today is lordship 1 year for.
No, whether victim has been examined or not.
Within this period, lordship, the case has been listed for 41 occasions for evidence.
No,
Lordship.
you are not answering my question.
Lordship, I am saying, lordship, that not a single witness has been produced, not a single witness turned up, lordship, in these days. And other all witness has been examined, lordship. Only lordship, informant and victim has not been examined, lordship. Normally, the
Victim's
lordship-
examination is necessary because
That-
you are the grandfather of the victim.
Grandfather, lordship, but lordship, normally, lordship, the informants is examined first, lordship. But in this case, all has been examined, and lordship,
Yes, what is your submission?
petitioner is 73-year-old, lordship.
Otherwise, lordship, the materials are there, lordship, hymen is stone and she is of 16 to 18 years. And to be honest, lordship, I have seen that as service awaited. So I think lordship, so I have not gone for the.
Yes, what is your submission?
Lordship. Lordship, considering the length of detention, if you.
Why you are not appearing before the court?
Lordship, I have to take instruction on the figure. Then I did to me.
Lordship, on 41 occasion, lordship, case was listed for evidence, lordship, and 1 year, 10 months has gone, lordship. I am 73-year-old person, lordship.
No, but victim, if victim is not, where is the FIR? Because you can easily
FIR
influence the
is a-
victim.
Lordship, lordship. The FIR has been lost by lordship. In fact, my lord, the grandmother of the victim, lordship, who is my sister also, otherwise, lordship, relatively, lordship. If at page, lordship, start from.
Only
lordship,
after examination of victim can.
Lordship, if they not.
We will issue
The prosecution
instructions.
failed to, lordship, for almost 2 years, lordship. I am 73-year-old, lordship. So.
No, when the informant and victim can approach this court in bail objection, why they cannot appear before the trial court?
Lordship, may kindly see the reports, the orders, lordship. All the dates orders is made to just reissue the notice, lordship. No concrete steps has been taken by the Ranipur lordship. No warrant, etc. has been issued.
Heard, Mr. What is the name?
J. Abbas.
J. Abbas, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor.
But I have been.
As well as Mr.
Islam.
R. Islam appearing for the informant, yes.
The victim is a different term, lordship, and that's why, lordship, the prosecution has not examined. You cannot hear and say, lordship. That's why what I have in instruction, lordship. For that reason,
I
lordship.
have also seen in the records, which is different.
Then, lordship, for that reason, if she is not examined, lordship, what is my fault?
Okay, we'll call for a report.
Report has come, lordship.
But I object, lordship, on the ground that they live in the same place, lordship. So she is in a predominant position also, lordship.
Not on same place.
This,
Victims lives in the house of the informant, lordship.
this application under section 483 of BNSS has been filed by the petitioner, namely Muhammad Talib Ali Joadar, alias Talib Ali Joadar, who has been detained behind the bars since 5/11/2023 in connection with special POXO case number. What is the special POXO case number? What is the case number?
Lordship, special case number 3 of life, lordship.
charge sheet has been laid.
Wait, my lord, can go the charge sheet very full, my lord. For the ends of justice. If you will kindly go through the FIR, my lord.
No, I have a query.
Now, two systems are here, my lord. One system, normally your lordship direct, but here he is inside the, my lord, inside.
But the trial court is the best court to decide
But that is,
after
yeah,
laying of the charge sheet.
but since it has
And-
come before your lordship,
And
there is
trial,
no bar, my lord.
trial court, there is no bar, but it is not proper. Let the trial court decide.
But proper, I think, madam, it is not improper, madam. Because this court, everything has come before your lordship. It is higher court. It all depends, it is absolutely your lordship's discretion, right? I'm not saying that, my lord, it should not go there. Yes, it is there, but since everything is before your lordship. But in this case, nothing, what is 17 years, something. this
Everything is not before me.
Scan copy has come means.
The trial charge sheet is,
Scan copy include certain one. So scan copy maybe call what time.
no. Instead of calling, you may go there. Heard Mr. H.R.A. Chaudhary, learned
It is a
counsel.
normal order, madam. I think your lordship may consider keeping in view of the fact of the case, madam. Fact of the case.
Learned senior counsel for the petitioner, assisted by Mr. A.B.T. Hoff,
It is okay.
A.T. Sarkar, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
But lordship, it is 135 stroke 25 dated 27/07/2025.
Since this court is of the considered opinion that after laying of the charge sheet, the trial court is the best court to consider the bail at the first instance. And since there is no embargo on the trial court, being the court of a special judge, to consider the application for bail and grant the bail if it deems it fit to do so. This bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised. Yes, also heard Mr. A.K. Azad, learned counsel appearing for the informant.
Almost.
Item 36.
May prison also. Regular bail application, my lord. Here is a case, my lord, where, my lord, the victim, the alleged victim and the petitioner, they were in a relationship, my lord. And, my lord, on the day of the incident, my lord, accidentally, my lord, the mother of the alleged victim discovered them sitting together in the house. And thereafter, my lord, with the instigation of the other parties, my lord, including neighbors, my lord, and landlord, this affair happened to be lodged, my lord. Lords will kindly see page number 12. This is the FIR.
This is a pending investigation.
Investigation.
Okay.
FIR is at page number 15, my lord.
Page number
15.
yes.
May I read, my lord?
Yes.
With all due respect, I beg to state that my daughter Pooja Biswas, residing at the address mentioned below, I work as a cook at people's houses. My daughter so-and-so is studying in class 7. I go out for work in the morning around 6 a.m. and return in the afternoon. My daughter so-and-so did not go to school today.
Prosecutor as well as Mr. N. Rahman appearing for the informant. This application under section 483 of BNSS has been filed by the petitioner under section by the petitioner who has been detained behind the bars since 12/8/2025 in connection with Gitanagar PS case number 62/2025 under section 65 within bracket 1 slash of BNS read with section 4 of the POXO Act. 4 is penetrative sexual assault. the gist of accusation in this case is that on 12/8/2025, the mother of the victim girl has lodged an FIR before the officer in charge of Gitanagar police station, inter alia, alleging that on that day, when the informant went to the house of other people for cooking, leaving her daughter within bracket victim in her residence, then with one security of like amount, subject to the satisfaction of learned special judge Foxo Kamrup Metro with following conditions. Condition number 1 and 2. Send back the case diary. This bail application is accordingly.
Item 47.
In this case, my lord, all the sections are available, my lord, except my lord 316. It is a criminal breach of trust, my lord, and there is no allegation of breach of trust in the entire FIR, my lord. My lord, may kindly see the FIR, my lord, at page, my lord, 31, my lord. My lord, the allegation, basic allegation is that, my lord, the petitioner here is a physiotherapist, my lord. And my lord, what he has done, my lord, as per the FIR, my lord. So he has used the pad where he has given one registration number is 15777. So, and the informant herein is, my lord, anti-quackery and vigilance officer of Assam Council of Medical Registration, my lord. So he says, my lord, that registration number belongs to one, my lord, one Anurova Roy, my lord, who has been registered in Assam Council of Medical Registration. That is the first allegation. The second allegation means, my lord, that I am not a doctor, my lord, so I cannot declare myself as a doctor. And thirdly, my lord, I prescribe medicines, my lord. So these are 3 allegations, my lord. So if we go by the 3 allegations, my lord, there is no allegation of criminal breach of trust, my lord, because the victim has not come before, has not lodged a complaint, my lord. It is an officer who has lodged a complaint. And even if you go by the definition of the criminal breach of trust, entrustment of the property is necessary, my lord, then convert it to his own use. This is not there in the entire affair, my lord. My lord, and now, my lord, if you go, my lord, the petitioner, my lord, is a physiotherapist, my lord. So the allegation against first allegation, my lord, that my registration number in my pad, which I have used, is 15777. I will take your lordship to my pass certificate, my lord. My petitioner is a physiotherapist. He passed out his, my lord, Bachelor of Physiotherapy, my lord. Lordship may kindly come to page 16, my lord.
No, where is your registration?
Yes, I'm just showing, my lord. Page number 16 is a pass certificate from Srivanta Shankardev University of Health Science, Guwahati, my lord. This is my pass certificate, my lord. Lordship may kindly see, my lord, my pass certificate. I did 5 years course in Bachelor in Physiotherapy, my lord. Lordship may kindly see in the 3rd line, registration number, my lord. My name is there, Muhammad Akramul Haq, my lord. Page 16, my lord.
Yes.
And my registration number is 0157777 of 2014, my lord. So, my lord, what has happened? There was some confusion on this, my lord, because the informant, my lord, informant is, my lord, Assam Council of Medical Registration that relates to MBBS course, my lord. I am a physiotherapist, my lord. So, my registration number cannot be with that of the MBBS course, my lord. That is the confusion that is there, my lord. So, my registration number is this, my lord. I pass out, my lord, from Regional College of Paramedical Health Science, Sonapur, Guwahati, my lord. In the year 2014, I admitted.
Since when are you behind the bars?
My lord,
This is
I'm behind the bar from, my lord, 2nd of, my lord, 12th of August 2025, my lord. Otherwise, my lord, otherwise, my lord, if you go by the content, my lord, I have just gone through, my lord, that the Assam Medical Council, my lord, Assam Medical Council Act 1999, which has been mentioned in the FIR, my lord. It shows, my lord, that if any persons prescribe medicines in violations of the, my lord, the provision of that act, my lord, the punishment is, my lord, only 1 year, my lord. This is also available, my lord. If lordship sees, my lord, that is may not be necessary because I am not charged with this section, my lord.
And you are using the prefix doctor.
Yes, my lord. Now to that extent, my lord, lordship may kindly come to page, my lord, 56, my lord. That is, my lord, I'm being, my lord, governed by an act, my lord. That is, my lord, National Commission for Allied Healthcare Professions Act, my lord. And my lord, and the Ministry of Health, my lord, has issued a, my lord, handbook, physiotherapy handbook, curriculum handbook, my lord. I will take your lordship to that curriculum, my lord, at page 56. About it start with 3.2, recognition of title and qualification. If lordship sees 3.2.2 and 3.2.3, my lord, lordship will say the commission recognizes any healthcare professional as physiotherapist who has acquired Bachelor of Physiotherapy from recognized universities, college as per the regulation of the commission. That I did, my lord. The recommended title thus stands as the physiotherapist with the prefix DR. So physiotherapist can also use DR, my lord, and with suffix PT means physiotherapy, my lord. So whenever I can write DR, my name, my lord, and thereafter I should write my BPT, I should write, my lord.
Physiotherapist.
Yes, my lord. So to that extent also, my lord, I suffice, my lord, that I can use, my lord, this DR can be used by a physiotherapist, my lord. But he should
DR
use,
can be used along with the
yes,
suffix.
yes, suffix PT, my lord. If I am Bachelor of Physiotherapy, then I should use, my lord, BPT. If I am Master in Physiotherapy, I should use MPT. So what the FIR say, my lord? FIR say that I used MPT, and to him it is unrecognized. My lord, may kindly see the second paragraph, my lord.
Where?
Second paragraph of the FIR, my lord. Page 31, my lord.
Yes.
Lordship, me see the third line, my lord. This individual has mentioned that he is the holder of some unrecognized qualification like MPT, orthopedic. MPT for him is an unrecognized, my lord, orthopedic. My certificate I have annexed, my lord, at page, my lord, 18, my lord. I have done my master in physiotherapy in orthopedic, my lord, and for him it is unrecognized from Mahatma Gandhi University. My lord, may kindly see type copy is page 17 and the copy, other copy is at page 18, my lord.
Yes, Ms. Das.
Lordship,
And my 35(3) notice has also not been given, my lord.
Lordship, he's,
And in addition to this, my lord,
Yes, Mahatma Gandhi University is a recognized university.
yes, my lord. From BPT, my lord, I can use, my lord, this is the master degree, my lord. BPT is there, my lord, Bachelor in Physiotherapy from this Srimanta Sankata University of Health Science, my lord.
Mr. G. Alam, Leonard Council. Yes, Ms. Das, you are.
Lordship, he is using the registration number 15777.
But that is the registration number of
Lordship,
Mahatma.
as per the Lordship, ACMR Lordship, Assam Council of Medical Registered Lordship, I have received the registered book Lordship. Here the registration number belongs to Orunabha Roy Lordship.
Yes. No, you cannot use that registration number. Registration no, it is your university registration number.
And he is providing a Lordship allopathic
Yes,
medicines since 2022 to the Lordship patients. Lordship.
That is.
Not Mr. G. Alam, Learned Counsel for the petitioner. Also Ms. N. Das, Learned Additional Public Prosecutor. Where is your rejection order?
My lord, rejection order at page, my lord. Rejection order at page, my lord, 42, my lord. That is because of early stage, my lord, it was rejected.
Okay, by the additional session judge. This application under section 483 of BNSS has been filed by the petitioner, namely Akramul Haq, alias Akramul Haq, alias Muhammad Akramul Haq, who has been detained behind the bars since 12/8/2025 in connection with Nagaon PS case number 635/2025 under section 319 within bracket 2/316 within bracket 2/336 within bracket 2/125/271 of BNSS 2023. The gist of acquisition in this case is that on where is the FIR?
Page 31, my lord.
That on 4th August,
It is my 7th August, my lord.
7th August 2025. One Durga Prasad Neog.
Abhijit Niyog, my lord.
Durga Prasad Neog. No, Abhijit Neog.
Yes, Abhijit.
Dr. Abhijit Neog. Anti-Quackery and Vigilance Officer, Assam Council of Medical Registration has lodged an FIR before the officer in charge of Nagaon Police Station, inter alia, alleging that the petitioner has been practicing medicine without being eligible to do so by showing a registration number which belongs to some other doctor. It is also alleged in the FIR that petitioner has shown his qualification to be an MPT within bracket orthopedics, which is an unrecognized qualification. It is also alleged in the FIR that without being eligible to do so, the petitioner is using prefix DR, doctor, DR before his name, and has been practicing allopathy. The learned counsel for the petitioner has submitted that the accusation leveled against the petitioner in the FIR are not true. He submits that except section 316
Bracket 2, my lord.
within bracket 2 of the BNS, all other offences which has been shown to have been committed, which are shown to have been committed by the petitioner, are bailable in nature. He further submits that from their perusal of the FIR, it would appear that there is no ingredient of section 316 in this case. He further submits that the petitioner has completed his bachelor in physiotherapy degree from Srimanta Shankardev University of Health Sciences, Guwahati, Assam, which is a recognized university. He submits that the registration number of the said university is registration number of the petitioner in the said university is 015777 of 2014, which is identical to what has been mentioned in the FIR, and therefore same is not a fake registration number. He also submits that the petitioner is using the prefix DR before his name as per the clause. Where is that?
Yes, page 56, my lord. And lordship may get, my lord, the curriculum, my lord, at page 45.
Clause 3.2.3 of the handbook
Yes.
published by whom?
Is a handbook, my lord, a National Commission for Allied Health Profession Competency-Based Curriculum, page 45 may seen, my lord. 45 and 46, my lord.
Published by National Commission for Allied and Healthcare Professionals as in the as per the National Commission for Allied Health
Professional
Care Professional Act 2021. A physiotherapist may use the prefix DR within inverted comma and suffix PT within inverted comma. He further submits that the petitioner has been detained behind the bars since 12/8/2025, and considering all the aspects, he may be allowed to go on bail. On the other hand, anything?
35A notice not served to us.
Learned counsel for the petitioner has also submitted that though the petitioner, what is 316 punishment?
316 my 5 years, my lord, or fine, or both, my lord.
Learned counsel for the petitioner has also submitted that for the offences alleged in this case, the maximum punishment prescribes may extend only up to 7 years, and therefore
5 years.
up to 5 years, and therefore there was a requirement of issuance of notice under section 35 within bracket 3 of BNSS, which was not served in this case to the petitioner. So upon the other hand, learned additional public prosecutor has produced the case diary of Nogao PS case number 36635/2025 and submits that there are materials in record that without being an MBBS doctor, the petitioner was practicing allopathy since last 2 years. He also submits that the petitioner was also using the registration number of another doctor registration number which was allotted to some other doctor and has been using the said registration number in the prescription pad used by the petitioner. What is the progress of the investigation?
Others also,
You have seized.
Yes, my lord.
Yes,
Caesar
your
leave, my
worship.
lord.
She, however, fairly submits that the investigation has fairly progressed in this case. So, I have considered the submissions made by learned counsel for both sides. Though there appears to be some incriminating materials against the petitioner in the case diary. However, without commenting on the merits of the case, this court is of considered opinion that considering the progress made in the investigation, as well as period of detention undergone by the petitioner, this court is of his further custodial detention may not be necessary for fair completion of the investigation of the Nogao PS case number 635/2025. So in view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Kamrup, Nogao, with following conditions, number 1 and number 2. Send back the case. This bail application is according with this court.
Obliged, my lord. Deeply obliged. Wait, please, lordship. That is a POCSO Act. Section 6 POCSO.
What is 6?
Item, section 6 POCSO Act.
No, what is 6? What is the offense?
Yeah. I was arrested on 21st of September 2024. Till today, 349 days. Charge sheet was submitted on 30th of November.
Recorded under section 183 of the BNSS. The victim girl has not implicated the petition. Where is the scanned copy? Monday. I'll go through the records. Let this case heard so and so, so and so. Let this case be fixed for delivery of orders on 11/9.
Obliged.
My lord, Boxer is there. In this case, instruction was called for whether service completed or not.
Yes, for the service completed, my lord.
My lord, amicus may be engaged and short date may be given, my lord.
Heard Miss Brown, you remain there. Heard Mr. A.K. Azad, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor, who submits that the notice issued to respondent number 2 has been duly served. Stop. No one has appeared for the respondent number 2. Hence, this court is inclined to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Ms. M.K. Brown, learned counsel whose name appear in the list of amicus curiae prepared by the registry of this court, is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. Registry is directed to reflect her name in the cause list. Henceforth, the learned counsel for the petitioner is requested to furnish a copy of bail application along with the annexure to the learned amicus curiae within 1 day.
My lord, by Monday, today almost is over.
Within 2 days from the date of this order.
My lord.
List this matter again.
Tuesday I am praying, it is more than 6 months he is behind the bar. My lord.
Let us see our board. 15th,
15, today is 5.
17th.
So long for me because my
No,
lord,
15 also, for my also difficult.
earlier than 15, my lord, earlier than
17,
15.
17. Earlier 15, then at 4:15, you will gather before me for mentioning
17,
17.
my lord. Item 60.
Maybe, Lordship.
Item number? Yes.
Lordship, the petitioner accused was arrested on 9/8/2025. Lordship, the FIR, Lordship. Lordship, page number.
What is the offense?
Lordship, the offense are under section 143(3) and 144(2) of the BNSS and section 5 of the Immoral Traffic Prevention Act. Today is the second day fixed for CD, Lordship. Last date also CD was not available today. So I may be heard, Lordship, I am claiming violation of fundamental rights and Article 22, Lordship.
No, unless we go through the case diary.
So I've annexed the copies of the notices also, Lordship, the grounds of arrest, Lordship. The FIR does not contain any allegation against me. Lordship, I am just a customer and I've been brought in under the Trafficking Act, Lordship. Being a customer, I cannot be brought under these 3 sections, Lordship. In fact, it is not even a... The ground of arrest is given, Lordship. If your Lordship peruses the ground of arrest, Lordship. Lordship, just the FIR, Lordship, if I may.
No, when can you produce the case diary? Wait till 11.
See.
Heard, Mr. What is the name?
It's a key Jain lordship.
Ejen.
It's a 10th lordship, 10. 10.
It
One
may not be possible.
11th or
Or you choose a date after 11.
That's 11th, 11th lordship.
Heard Mr. T. Jain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case that prayer is allowed. Let this matter be listed on 11th of September.
Obliged.
My please, your lordship. My lord. Interim order is there in favor of.
Heard Mr. What is your name?
S.H. Mahmood.
S.H. Mahmood, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case that the prayer is allowed. Let this matter be listed on 14th of October. The interim order shall continue till next day. Yes.
Lordship, this was a case under 22 NDPS. Your lordship had ordered for the case diary, but it had not come.
22
See,
C.
yes, your lordship.
You are praying for anticipatory bail.
Yes, your lordship. The CD was not there, so your lordship had ordered for the CD to come for deliberation. The CDs were not done.
Case diary is there.
It is available.
Okay, yes. What is the submission?
Your lordship, the submission shall remain the same. First of all, the concerned substance was found in the car, that is in the, even though in the constructive custody, but not in the conscious possession of the person. So therefore, the police has not been able to, investigation agency has not been able to show from the get-go that it was the intent of the person to do any illicit or.
Car is a public taxi or private car.
It's a private car. Your Lord.
It belongs to you. You
Yes,
are the
Your
owner.
So that is what. But it has been used by the members of the locality, your lordship. It's like in smaller areas, you don't really have commercial cars. People use their cars to give out for hires and other things like that.
Okay.
But subsequently, your lordship, the police had said that the person was identified later as to be the petitioner. But that has to be still corroborated, your lordship.
No, at this stage of investigation,
It already.
you will get bail if this court comes to a prima facie conclusion that you are innocent.
Your lordship, their basis of making this case against us has only been because there was a case previously pending against the petitioner. That is why his name has come up so frequently, and they have made the same point in the FIR as well. But in that case also, the client has not been absconding, he's been contesting the case. The case which they have mentioned. To be
Where is the FIR?
Page 11. Your Lord.
What is your name?
Nazir Kazi, alias Boga.
Fourth parallel. Last July.
So what is your submission? You ran away after seeing the police. Yes. How you will overcome 37, embargo of 37?
Your Lordship, I am arguing that I was not at the house because they have clearly said seeing police party, male adult who is run away, later identified as Boga. Now everybody there knows that there is a criminal case going against this person, and the police already has their prejudice against this person
based on the case ongoing, which is mentioned in the next page, Your Lordship, page 12. Bayata Chariali PS case 161 of 2022. So my contention is that there needs to be independent corroboration of these facts that it was indeed him who has fled the scene or who has like procured all this.
But investigation is going on.
Lordship, if you
Okay.
look,
What was recovered?
it is Lordship,
240 bottles.
codeine phosphate,
240
240 Lordship. 10 bottle, above 10 bottle is
Yes,
commercial.
any other submission? Yes,
Lordship, here first I want to state here, Lordship, not only the car, Lordship, it is in the, under the bed, and it is also from the kitchen of the house, Lordship. And moreover, it is a commercial quantity, and moreover, on the top of it, Lordship, this is anticipatory bail in commercial quantity, Lordship. I may refer to one citation, Lordship.
Small judgment from.
Small judgment, Lordship. Para 4 and para 9, Lordship. Para 4, may I read, Lordship?
yes.
The High Court decided to grant pre-arrest bail to the respondent on the only ground that no recovery was effected from the respondents and that they had been implicated only on the basis of disclosure statement of the main accused, so and so, Lordship. Therefore, here we are in a better position, Lordship. It is from recovered from his conscious position, Lordship. May I read para 9, Lordship?
Yes.
To grant anticipatory bail in a case of this nature is not really warranted, Lordship, anticipatory bail. Therefore, we are of the view that the High Court falls into an error in granting anticipatory bail to the
No,
respondent.
that observation is in respect of the facts of that case.
Lordship, but in that case, Lordship, recover, not recover. From his position. That is important, Lordship. Here, it is from recovered from his position.
Heard, Mr.
Lordship, not possession, custody.
Conscious position, Lordship.
Heard, Mr. What is the name?
A. Mishra, Your Lordship.
A. Mishra, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Application under section 483 of BNSS has been filed by the petitioner Nazir Kazi alias Boga, who has been detained behind the bar, who is apprehending his arrest in connection with Bayata Chareli PS case number 61/2025 under section 22C of the NDPS Act. The gist of accusation in this case is that on 6/3/2025, one Daisy Nath, SI of police of Bayata Chareli PS had lodged an FIR before the officer in charge of Bayata Chareli police station, inter alia, alleging that an information was received through reliable sources that the petitioner has kept huge quantity of cough syrups for selling in his Alto car and scooty. Accordingly, a team of police was constituted and it rushed to the house of the present petitioner. It is stated in the FIR that when the police team reached the house of the petitioner, they noticed one person running away from the house on seeing the police party. And later on, it was found that the said person was the petitioner. During search of the house of the petitioner, some cough syrup were found kept under the bed, inside under the bed, in the kitchen of the house, as well as in the dicky of the Maruti Suzuki vehicle bearing registration number AS01AK 4465. Learned counsel for the petitioner has submitted that nothing was found from conscious possession of the petitioner, as petitioner was not there at the time when search was made in his house. He further submits that the identity of the petitioner as the person fleeing away from house on seeing the police is also not true. He submits that the petitioner's name has been involved, has been incorporated by the police in the affair, as earlier also one case, that is Bhattacharya NDPS case number 161/22 was is pending against the petitioner. Stop. He submits that there is no material to corroborate that it was the petitioner who flee away from the place of search on seeing the police. Therefore, submits that this is a fit case to grant of bail to the petitioner in this case. On the other hand, learned additional public prosecutor has vehemently opposed the grant of anticipatory bail to the petitioner in this case, and has produced the case diary of.
Lordship, may I submit one thing, Lordship, if may allow, Lordship. Here, Lordship, one of the witness, his own brother, Lordship, he has himself submitted, Lordship. ওপৰত মোৰ নাম ঠিকনা
He has identified.
He has identified.
Okay.
বগা নাম মোৰ নিজা ভাই হয়। আৰক্ষী দেখি নজিৰ পলায়ন কৰাটো সঁচা।
Okay. क्या लिखा? And has produced the case diary of Bhattacharya NDPS case number 61/2023. And has submitted that the contraband seized in this case is of commercial quantity, and therefore embargo of section 37 of the NDPS Act is applicable to this case. He also submits that there are sufficient materials in the case diary to indicate that seized contraband was recovered from the house of the petitioner, and it was the petitioner who fled away therefrom on seeing the police party. Stop. He has submitted that in view of the incriminating materials against the petitioner in the case diary, this is not a fit case to grant of anticipatory bail to the petitioner. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. On perusal of the case diary, it appears that there are sufficient materials indicating that the seized contraband, which is of commercial quantity, was recovered from the house of the present petitioner. And there are also materials to indicate that the petitioner fled away from his house on seeing the police. Stop. Under such circumstances, the embargo of section 37 of the NDPS Act is squarely applicable to this case, in which this court is of squarely applicable to this case. Stop. This court is of considered opinion that the petitioner has failed to overcome the said embargo. Hence, this is not a fit case where anticipatory bail may be granted to the petitioner. Accordingly, the prayer for anticipatory bail is rejected. Send back the case diary. This anticipatory bail application is accordingly disposed of.
My lord, I am extremely sorry, my lord. Item 38, during the pendency of this AB, one person, that is Gopal Sarkar, has been arrested. So his name may kindly be struck off, so that we may file regular bail application. Item 38. My junior was here.
Item 38 of learned counsel for the petitioner has submitted that during the pendency of this case, the petitioner number
One Gopal Sarkar.
one Gopal Sarkar has already been arrested.
He
and
was
they-
not on interim.
And therefore, this anticipatory bail application,
Gopal Sutradhar, sorry, man.
Gopal Sutradhar has already been arrested, and therefore this anticipatory bail as regards the said petitioner has become infructuous. And therefore, he prays for deleting the name of Gopal Sutradhar from this bail application. The prayer is allowed. The petitioners are directed to file an amended cause title in this case before the next date fixed.
Highly obliged.
Item 40 and 41.
I got that. Yes,
My lord, it's a second application, my lord. Earlier rejected by your lordship, my lord. If there was call for, my lord.
Charge sheet submitted, Lord.
charge sheet submitted.
What I am praying, my lord, it's a session trial case, my lord. And once your lordship has rejected, my lord. So I prayed, my lord, LCR and the case diary may be called for, my lord, because my prayer will not be considered there because of the rejection of this high court, my lord. So LCR and case diary may be called.
What is session tribal?
At 1091 and 1182, my lord. Voluntarily causing grievous hurt and attempt to murder, my lord. There was injury also there, my lord. And there is this fight between the cousin brothers, my lord. And all the family members, my lord, been named, my lord. The brothers, all the brothers, my lord, been named, my lord. So, my lord, LCR may be called for, my lord. And my lord, last occasion, my lord, when your lordship rejected my bail application, my lord, only FIR was annexed, my lord, with the bail application, my lord. There was a civil dispute, my lord. I have annexed the title suit, my lord, petition, my lord, and the order of the
Heard.
title suit, my lord.
Mr. A. Hussain.
SM Mullah, my lord. In
Mr.
item number 40, my lord,
Mr. S.M. Mullah,
my lord.
learned counsel for the under what provision charge sheet has been laid? How you came to know?
In the last occasion also, my friend, case diary was called for, my lord. Grievous injury was there.
But we don't know. Under
Which section? Let the LCR come, my lord, because it's session trial case, my lord, because
this is speculative.
if I have annexed the, my lord, last order, my lord, your lordship's order, my lord, case.
But in the last order,
Please observe, my lord, the injury is there, my lord, grievous, my lord. An attempt to murder is there, my lord, it is 10 years, my lord.
no, you verify from the charge sheet and then you approach.
You can fix a date, my lord, will collect the charge sheet certified copy, my lord. Otherwise, that court will not consider, my lord, because nowadays we have to annex all the orders, my lord, if bail application was filed, my lord.
Heard Mr. S.M. Mullah, learned counsel for the petitioner, who submits that since offense under section 307, 10,
109, my lord,
109
and 118.
and 118 of BNS are involved in this case, for which the punishment is
Extend to 10 years, my lord.
extended to 10 years.
My lord, that 109, my attempt to murder, if injury is there, my lord, then up to life, my lord. 109.
For which the offense, for which the punishment within bracket in respect of offense under section 109 may extend to life imprisonment.
My lord.
Therefore, he submits that there is unlikelihood of the petitioner getting bail even if they appear before the committal court. And therefore, he submits that the petitioner may be allowed to file an additional affidavit to bring on record the charge sheet and other relevant documents. The prayer is allowed. Let this case be listed when 23rd November, September.
I am applying for item number 41.
Same prayer. What is your name?
Yeah.
Same order. Council number KL.
Scan copy thereafter, after filing of charge.
If required.
If required. Obviously.
Item
44.
Yes.
Service report is submitted.
This is POXO case. Notice has been served. Heard.
Notice issue.
What is your name?
Mrs. Begum.
Heard Miss A. Begum, learned counsel for this. Amicus on this. Heard Miss A. Begum, learned counsel for the petitioner. Also heard Miss N. Das, learned additional public prosecutor, who submits that the service report, the notice issued to respondent number 2 has been duly served. Stop. Since no one has appeared for respondent number 2, this court inclines to appoint one amicus curiae to defend the cause of respondent number 2 in this bail application. Accordingly, Mr. N. Mahajan, any amicus is present in this court? Yes, accordingly, Ms. Srimati Pooja Agarwal is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this anticipatory bail application. The petitioner is directed to furnish a copy of anticipatory bail application along with annexures to the newly appointed amicus curiae. The registry is directed to reflect the name of Ms. Pooja Agarwal as amicus curiae in this case. When can we fix? 19th.
Please, we late.
18th.
18. Yes,
Let this case be listed again on 18th.
Item 45.
oh, bless. They did not receive lordship.
We have taken steps today itself, lordship.
Today,
Today, POXO phone,
heard Miss, what is the name?
J. Ghosh.
J. Ghosh, learned counsel for the petitioner. Also heard Miss N. Das, learned additional public prosecutor, who seeks some more time for production of the case diary. The prayer is allowed. Let this case be listed on 19th of October, September, sir.
In this case, my lord, petitioner before your lordship is a driver, sorry, my lord, owner of the truck, my lord, which was allegedly found, my lord, carrying some, my lord, gold flag cigarette, my lord, branded. But department is suspecting that, my lord, this gold flag may be, my lord, foreign origin, my lord. But so far, my lord, I know gold flag are Indian made, my lord, and it is also they are mentioned. It is, my lord, Indian made, my lord. Lordship, kindly have a look, my crux of the, my lord, allegation is precisely, my lord, page 11, my lord, Roman 3, my lord.
What is your submission?
Submission is that, my lord, admittedly, my lord, the petitioner before your lordship is a, my lord, owner of the truck, my lord, and he is ailing person, my lord, presently. And this truck was driven by one Shamim Ahmed, my lord, Lashkar. And this truck was basically monitored by, my lord, his elder son, my lord, whose name is Parvez, my lord. He was also not there, my son, my lord. And but driver and two other persons were, my lord, arrested with this truck, my lord, from Julabat, my lord. And some cigarettes were, my lord, recovered, gold flag, made in India, my
Oh, it is under Customs Act.
Customs Act, my lord,
What are the offenses?
3 years, my lord.
No, what is the offense?
Lordship, he is the Lordship petitioner is the owner of the truck. Lordship. And his son, Parvez, he was driving the truck from where the foreign cigarette was recovered, Lordship. And several notices were issued to them. Till now, they have not appeared, Lordship. We have received CD.
My lord, my learned friend, my lord, saying that, my lord, notice was issued, but no notice, my lord, he received. He received one, my lord, there, he, my lord, continuously with the, my lord, connection with the, my lord, DRI authority. Recently, my lord, one notice issued to him, my lord, showing him cause, my lord, as to why this truck should not be confiscated, my lord. And it was also, my lord, advised him, my lord, to submit his report before the, my lord, director, my lord, at Shillong, my lord. Therefore, he has gone yesterday.
What is the punishment for
My lord,
offense under 10?
3 years, my lord.
3 to 7 years, Lordship.
104? Customs Act. So whether his custodial interrogation is necessary.
Should appear before DIO and record their statement is necessary, Lordship.
Notice under 35(3) has been issued.
Several notices are issued to him, Lordship.
Notice under what provision? 35(3). Or
New probation is like that, my lord. But he is, my lord, regularly visiting their officer. Some, my lord,
where are the notices?
my lord, another
In the
development.
record.
Yes, Lordship.
Another development is there, my lord.
Summons were issued to him.
In the meantime, my lord, trial court, my lord, granted him the Jimma of the vehicle, my lord. Therefore, to take the Jimma of the truck, my lord, this honorable court last occasion given him, my lord, some interim protection, not to, my lord, take any coercive action against him, my lord. Therefore, my lord, he is processing now to take Jimma of the vehicle from the authority, my lord. He is regularly going to their office, my lord. But how?
Oh. So
Perhaps, my lord, this notice was specifically not communicated with him, my lord. Otherwise, my lord, once, my lord, my learned friend also, my lord, to help him, my lord, in the, he does not know English, my lord, and Hindi, also help them, my lord, in their office, my lord, with IO, my lord. But we are saying not appeared, my lord. He appeared, my lord, very much appeared.
when you appeared?
My lord, a few days ago, my lord, he
No, Lordship, they
4
went to
times.
this for claiming Jimma of the vehicle, Lordship,
Yes,
not
ma'am.
for recording statement.
And so, otherwise, my lord, in the interim order, there is no such, my lord, direction to record the statement, etc. But he is regularly in touch with the DRI authority, my
Third, Mr. A.M. Bordmia. This is item number
61, my lord, supplemental.
A.M. Bordmia, learned counsel for the petitioner. Also, Ms. M. Deka, learned counsel for the Custom Department. DRI, learned counsel for the DRI. This application under section 482 of BNSS has been filed by the petitioner, namely Syed Ali Laskar, who is apprehending his arrest in connection with DRI case number. Why are you apprehending your arrest?
My lord, he is the owner, my lord.
No, but if you have not received any notice,
Because owner, my lord, therefore he is apprehending. This is the ground.
apprehending his arrest in connection with DRI case number 26/CL/IMP/CIG/DRI/GZU 2024-2025 under section 110/104/135 of the Customs Act 1962. The gist of acquisition in this case is that on that the Union of India, represented by the intelligence officer DRI, has, you have filed the complaint,
Yes, my lord. Page, my lord, relevant portion, page 10, my lord, paragraph.
has filed a complaint before the Court of Learned Chief Judicial Magistrate Kamru, inter alia alleging that on receipt of an information through reliable sources that one vehicle bearing registration number AS26C9100 as well as another safari car. Which is your vehicle?
Well, my track, my lord.
As well as an two six seven double zero was carrying, would be carrying huge quantity of foreign made cigarettes. So, comma, a search team was constituted and the said truck was intercepted. During the search of the said truck, cigarettes which are suspected to be foreign made of various brands were recovered therefrom. And accordingly, a complaint under section 110/104/135 of the NSS of Customs Act was filed. Learned counsel for the petitioner has submitted that the petitioner is the owner of the vehicle and the offenses involved in this case does not prescribe punishment more than 7 years. And therefore, he submits that the petitioner is entitled to get notice in this case, notice under section 35(3) of BNSS in this case. He further submits that the petitioner came to know about the case when he got information regarding seizure of his vehicle in connection with the aforesaid case. He also submits that in the meanwhile, the trial court has granted Jimma of the said vehicle to the petitioner. However, he is apprehensive that if he appears before the DRI to seek Jimma of the said vehicle, he may be arrested. So, he further submits that the petitioner is ready to cooperate in the investigation. And the nature of this case is such that his custodial interrogation may not be necessary. On the other hand, learned counsel for DRI has produced the records of investigation of the case and has submitted that the interrogation of the petitioner is necessary for fair completion of the investigation. However, in spite of several notices issued to the petitioner under section 108 of the Customs Act, he has not notices / summons issued to the petitioner under section 108 of the Customs Act. He has failed to appear before the investigating officer, and therefore you are opposing. Therefore, she opposes the grant of anticipatory bail in this case. I have considered the submissions made by learned counsel for both sides and have gone through the records produced by the learned counsel for DRI in this case. It appears from records that the DRI has been issuing summons under section 108 of the Customs Act to the petitioner on several occasions. However, he has failed to appear before the DRI in person to the summons. The learned counsel for the DRI, however, submits that on one occasion, the petitioner has appeared before the DRI to seek Jimma of the seized vehicle. This court is of considered opinion. After perusal of the materials on record, this court is of considered opinion that since the offense involved are not punishable for a term of imprisonment more than 7 years, if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary. Accordingly, this anticipatory bail application is disposed of with a direction to the petitioner to appear before the investigating officials of DRI in connection with the above mentioned case within 7 days from the date of this order.
I don't expect 10 days. Just after 15 days, he has gone, just started.
10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the above mentioned case, he shall be allowed to go on bail of ₹30,000 with one surety of life month, subject to the satisfaction of the arresting authority. Send back the case diary. This bail application is accordingly disposed of. Condition 1 and 2.
One small prayer with regard to item number 25. Registry will be directed to respect my name in the court list. Item number 25.
Lastly, I am for the petitioner of the 25. There is some urgency, Lastly. Due to pendency of this revision petition, the trial court is not framing the charge. That's why.
Why there is no bar? Is there any
No,
stay?
based on the prima facie, Lordship, Honorable, this court, another court,
Item number
granted bail to the petitioner, Lordship.
Admission.
Coordinate benches granted the
Sir,
bail.
what is your name?
Ad hoc, Lordship.
Ad hoc learned counsel for the petitioner. Also Ms. P. Agarwal, learned amicus curiae. This matter could not be taken up due to paucity of time let this be fixed in the date.
On the trial court matter is fixed on 26th, Lordship, for framing of surface. It will be before the.
26 or 24th of September. Stop. The registry is directed to reflect the name of Miss Pooja Agarwal as amicus, as engaged as amicus curiae in this case, in the cause list henceforth.
Can it be on 25th, Lordship?
25th. Remaining matters.
Can it be on Monday?
No, Monday, you know.
Please, my lord.
Yes.
48, my lord. It was served for justice service. We were to serve to give us the date. Something the petition met with an accident, so we could not comply with it. It is already served to the opposite party, my lord. Number 2. So justice service may be dispensed with, or we will take after.
No, we will
before
not pass
vacation.
any orders today. It will be shown as leftover. We may fix it on, okay. So it will be shown as leftover. The other side has already appeared. You need not to take.
After,
No, registry will fix that. All leftover matters, registry will fix that.